Any mention? Daily list item number 1.
May it please your lordship.
Yes.
May it please your lordship. Lordship, in this matter we are filing a rejoinder affidavit today, lordship. Lordship,
the day. Who's for the other side? M. Mircham. Where's
P. Agarwal.
Yes.
Correspondent number 225.
Very good. Yes. Your name MD.
B Sarma, lordship.
MSB Sarma submits that the rejoinder will find the course of the day. We list for hearing after. Yes. List for hearing after 3 weeks. Yes.
Lordship, interim is there.
Interim is there.
Yes, lordship.
Interim order to continue till next day. Yes.
2.
Lordship, in 2, lordship, the Mr. Conducting Counsel could not come down, lordship. Lordship may take up this matter after 1 week, lordship.
Where's the other side? Where's MS who appeared last time?
Yeah, some lordship.
Who's for the state? It's for the state. Yes.
Meghalaya, yes, lordship.
Where's the RP General we saw him just now? Yes. Yes.
Yes, my lord.
What's it for today?
Yes, my lord. Yes, request was made by the learned.
Lordship may take up this matter after 1 week.
Not 1 week. Have you supplied copies of eligible? Was supplied? Yes. MSB Sarma praised that the matter be adjourned due to the ability of the arguing counsel. Same objected to
Interim is there, lordship.
by the learned application on behalf of the respondent. This after 3 weeks. Yes. Interim order ready to continue to next day.
Supplementary list item number
DP
1.
applies.
May it please, your lordship, this is the matter.
This matter could be taken up after some time, my lord.
Yes. This is the end of the board we reach.
Hello.
Yes. Yes, Mr. Archival General.
Yes, my lord. This is Meghalaya College Teachers Association, my lord. I have filed a compilation, my lord. The lordship will have the compilation, my lord.
Just filed on.
Filed on last date of hearing, my lord.
Date to compile. This is
Compilation,
petition. Yes, yes.
document compilation, my lord.
Yes.
Running into 139 pages, my lord.
9 pages. Out here it's run through
6 July.
139 pages. 139 pages.
139 pages. my lord.
Yes.
Yes, my lord. Now, your lordship have this compilation and the prayer in the repetition. My lord, kindly have the prayer in the repetition also. Prayer in the repetition, because the issue is becomes significant, my lord, after your lordship goes through the prayer in the repetition, which is at page 44, my lord.
Amended petition.
Yes, amended petition 281 of 2020. 281, my lord.
1 second. 2 minutes.
Amended as per order of 2017, my lord.
The prayer.
Yes, my prayer. Because this is the matter on remand, my lord. Your lordship will have to, your lordship need to keep fact in mind that this is an order on remand, because one round of litigation has already taken place between the parties, my lord. So your lordship will see the prayer at page 44. My submission is that the prayer has been satisfied and nothing survives in this matter, my lord. Kindly see the prayer, my lord, page 44, and also in the light of the direction or the remand order passed by the Honorable Supreme Court. Prayer 1 at page 44 is, my lord.
Yes.
Directing all the respondents to take immediate steps to strictly comply with applicable provisions of the Contributory Provident Fund Scheme which was adopted by Government of Meghalaya, along with amendment insofar as college teachers of deficit grant in college in state of Meghalaya are concerned, with effect from the date on which the scheme was required to be effective. Two, direct the respondent to ensure that college teachers of deficit given their due benefits under the provisions of the aforesaid scheme with effect from the date on which such a scheme is being effected. Three, direct the state respondent to ensure effective penalties are leveled on any and all respondents who have failed to comply with the provisions of the aforesaid scheme. Four, further direct the state to formulate and finalize a scheme for effectuating a post-retired social scheme for teachers and deficit grant. And five, direct the state respondent to implement the state government pension scheme to teachers. These are the prayers which are there in writ petition 281, my lord. Lordship, now kindly come to the compilation. Now, this matter, my lord, travelled to the Honorable Supreme Court. Order was passed, and the Honorable Supreme Court, my lord, at page 24, my lord, Lordship have allowed the appeal of the state, my lord, against the direction passed by this Honorable Court, Division Bench of this Honorable Court, page 24 of the compilation.
Yes.
Now, paragraph 1, my lord, I will replace this judgment because this is irrelevant, my lord, for the purpose. Feeling aggrieved and dissatisfied with the impugned judgment and order dated 1/11/2018 passed by the High Court of Meghalaya at Shillong, 281 of 2017 and 360 of 2017, by which Division Bench of the High Court, while allowing the said petition, has issued the following direction. The state of Meghalaya has preferred the present appeal. By the impugned judgment and order, Division Bench of the High Court has issued the following direction for correction of contributory provident fund immediately with retrospective effect as per contributory fund rules 1962 and Assam Deficit College Reply Rules 1998. Teachers who joined services on or before 1/4/2010 can be given the benefits of new defined contribution schemes with effect from 1/4/2000 instead of 1/4/2018. Teachers who have retired joined prior to 1/4/2010 as well as those who are still serving and also who retired after still till 2018 and future benefits of Assam Non-Government Deficit College Pension and Provident Act and Assam so and so to be given with respective effect. 4. Government to frame rules for all pensioner benefit. 5. I'll just highlight the prayer, my lord. Government to also take immediate care to clear the monthly salary of teachers. 6. Government to make rules that none of the teachers should lose a single paisa. 7. Should pay the contribution which are supposed to be paid from time to time in section statute. 8. It is also directed that no tax should be deducted on the contribution made by teachers. 9. Government fails to correct, etc. So these were the prayers which were allowed in the previous round of litigation by this division bench, my lord. Now, appeal was preferred, my lord. And in paragraph 3 of next page, my lord, in the writ petition, original writ petition as such prayed for following relief, my lord. Now, lordship, the relief which I have already stated, my lord. Now, paragraph 4, my lord, of page 27 of the Honorable Supreme Court order. From the impugned judgment order passed by the High Court while issuing some of the direction, it appears that High Court has gone beyond the pleading in the main writ petition or even relief prayed for or sought in the main writ petition. My lord, kindly mark that it appears the High Court has gone beyond the pleadings in the main writ petitions, even the relief prayed for sought in the main writ petition. Even otherwise, some of the directions which are impugned are unsustainable and could not have been issued by the High Court in exercise of power under 226 of the Constitution. The direction issued in terms of part number 4, 5, 6, 7, 8 could not have been issued by the High Court, being policy decisions or being too vague while exercising power under 226 of it. Therefore, direction issued in 4, 5, 6, 7, 8 are quashed and set aside. So, state succeeded in appeal so far as these directions are concerned, my lord. Now, 5. Now, insofar as other directions issued by the High Court are concerned and relief sought in the main petition are concerned, what can be called out is the grievance on behalf of the petitioner is non-implementation of the provisions of Assam Government School and College Employees Centralized Permanent Scheme Act 1969, which has been adopted by State of Meghalaya, and State of Meghalaya has enacted its own act, namely Meghalaya Non-Government School College Employees Centralized Permanent Act 1969. 6. Learned Counsel appearing on behalf of the state is not disputing that Assam Act 1969 has been adopted by State of Meghalaya as per Meghalaya Act 1969. Therefore, as such, state is bound to implement and or act upon the Meghalaya Act 1969 and the regulation on a scheme, if any, framed thereunder. It is the case on behalf of the state that a forced provision scheme, if any, is being implemented in true spirit which is disputed by learned counsel appearing on behalf of the original petitioner. 7. From the impugned judgment and order passed by the High Court, there is no clarity as to which provisions of 1969 Act and regulation, if any, made thereunder or provident fund scheme adopted by the state of Meghalaya have not been implemented. Allegations are two-way. From the impugned judgment and order passed by High Court, nothing can be culled out as to which part of Meghalaya Act 1969 regulation or scheme, if any, framed thereunder or Assam Act are not implemented and to what extent they are not implemented. Only they are vague government allegations. High Court ought to have given a specific finding as to which part of the Act 1969 and the regulation, if any, framed there are not being implemented or complied with by the state before issuing a writ of mandamus. My Lord, kindly mark, the High Court ought to have given a specific finding as to which part of the Act 1969 and the regulation, if any, framed thereunder are not implemented or complied with by the state before issuing any. So, a scheme, which part of the Act or the scheme which is not being implemented, my Lord, that is the remit of the matter. My Lord, kindly have, my Lord, 8. Learned counsel appearing on behalf of the original writ petition has also conceded the writ petitioner before the High Court and the grievance on behalf of the original petition be confined to non-implementation of provisions of Assam Act 1969 adopted by State of Meghalaya by enacting Meghalaya Act 1969. He does not press for any other relief, including implementation of contributory provident fund scheme incorporated in Assam Aided College Rules 1969. So the abandonment is there. There is no 9. In view of the above, as there is no clarity at all and or a specific finding given to by the High Court to what extent the Provident Fund scheme framed under the Meghalaya Act has not been followed or implemented, we have no other alternative remedy to remand the matter to the High Court to consider the writ petition afresh with respect to allegation of non-implementation of Provident Fund scheme framed under Act 1969. As observed earlier, all other direction in terms of paragraph so and so deserve to be questioned, set aside and to be questioned. Insofar as direction issued by High Court with respect to pension scheme is concerned, in absence of any specific prayer or writ petition, same ought not to have been or could not have been granted by High Court. Therefore, direction with respect to same is quashed and set aside. In view of the above, for the reasons stated above, the present appeal succeed in part. Direction contained in para so and so in the are set aside. The matter, may not kindly mark this, matter are remanded to the High Court to consider the grievance on behalf of the original petitioner with respect to non-implementation of Meghalaya Act 1969 and the Provident Fund scheme under the Forced Act, if any. To what extent it will be open? To that extent, it will be open for the original writ petitioner to amend the writ petition, to which it will be open to file the counter affidavit. However, it is specifically made clear that remand shall be only to consider the implementation of Meghalaya Act and Provident Fund scheme, if any, and the High Court on the basis of pleading to consider part of 19 has not been complied or state to what extent same has not been complied. Only for the aforesaid purpose, the matter are remanded to the High Court. High Court is finally to decide and dispose of the petition on remand within a period of 6 months from the date of receipt of the present order. So the issue is, my Lord, confined to implementation of 1969 Act only, my Lord. Whether the Act has been implemented by the state government or not, Lordship kindly have the Act, my Lord, which is at page 1 of the compilation.
Yes.
Lordship, if your Lordship will see the Act, it's very brief Act, page 1, my Lord. And preamble, my Lord, Lordship will notice an act to make provisions of the creation of centralized provident fund. My Lord, the preamble immediately after the bracket. Yes. An act to make provisions for creation of centralized provident fund and framing of a scheme thereof for the employee of non-government schools and college of Meghalaya and its administration by board of trustees. So the act is for the purpose of creation of centralized provident fund and framing of a scheme thereof of the employees of non-government schools and colleges in Meghalaya and its administration by board of trustees. So there will be there will be centralized fund and there will be board of trustees who will manage the fund, my Lord. Preamble, where it is expedient to make provisions the creation of centralized provident fund and framing of a scheme thereof for the employees of And whereas it is further expedient to administer and control the said fund by Board of Trustees to safeguard the interest of subscriber by proper investment of deposit to extend additional retirement or other benefits to subscribe in gradual stage. So there will be expedient to administer control the said fund by Board of safeguard the interest. So there will be Board of Trustees who will safeguard the interest, my lord. Now, coming back to my lord, the provision, my lord, 2B, my lord, your lordship will have 2B. What definition of trustees in 2B, my lord? 2B is Board of Trustees means Board of Trustees to be constituted by state government as per a scheme framed under 4.1 of the administration of funds. So Board of Trustees will be as per the scheme framed by the state government, my lord. The 2B defines, my lord. Employer and employee are defined, my lord. That may not be relevant, my lord. Then the lordship will have the 4.1 straight away, my lord. Now, lordship may take note of 2J also, my lord. 2J. 2J is scheme. On the same page, page 13, my lord. A scheme means Meghalaya non-government school and college employees centralized provident scheme framed under 4.1 of the Act, my lord.
Yes.
Now 4.1 your lordship will have because the same. The state government, my lord, kindly note, state government may by notification in the official gazette frame a scheme to be called Meghalaya non-government school and college employees centralized provident fund scheme to be administered by Board of Trustees to be constituted by government under this scheme. My lord. So two things, two mandate to the government by the legislature. My lord. One, by frame a scheme, state government is required to frame a scheme to be called Meghalaya so-and-so scheme, and two, to be administered by Board of Trustees to be constituted by government under this scheme. Two, my lord, a scheme framed under the provisions of subsection 1 may provide for all or any of the matter specified in the schedule. So discretion is also vested with the state government to follow the schedule to extent the government deems it appropriate, my lord. Now 5, my lord. The scheme framed under this Act may provide that any of its provisions shall come into force with effect from such date as may be specified in behalf in the scheme, and different dates may be appointed different provisions of the scheme. 6, my lord. The state government by notification in the official gazette had to amend or vary a scheme framed under this Act. So the scheme can be amended, varied time to time by government by changing the schedule, my lord. Now, the question now which calls for your lordship's consideration in terms of the remand order of the Honorable Supreme Court is whether the government has framed the scheme under the Act or not. If it has framed the scheme, it has implemented the Act, my lord. It has implemented the Act, my lord. Now kindly see the process, the scheme and Board of Trustees have been, my lord. Scheme, I will take your lordship to the scheme straight away at page 116, my lord, of the compilation.
Okay, we have the scheme.
116. So
116.
one, sorry, one. Yes, my lord. 131, my lord.
131. You do one. 18 March. What is the date here?
It's a date, my lord.
8 May 26.
8 May 2026, my lord.
What is the date?
131. Your lordship has paid.
Not the same thing.
116.
131, yes.
Now, my lord, before I take your lordship to 131, just have 116 where the notification, gazette notification. I'm sorry, my lord. 116, my lord. 18th March 2026. 116, my lord.
Yes.
Where is the, my lord, your lordship has page 116, my lord.
Yes.
Whereas the state government recognizes the necessity of ensuring financial security, social protection to employees of non-government schools and colleges through a structured and sustainable provident fund mechanism, and to provide continuity of service, post-retirement security and welfare of employees, and where establishment of centralized provident fund is essential for ensuring uniformity, transparency, and efficient management of contributions, withdrawal, investment, and retirement benefits of such employees. And whereas the Act of State where empowers the state to frame a scheme for the administration and regulation of said fund, now exercise power conferred under subsection 4 of Assam Non-Government Act as adopted by Government of Meghalaya is pleased to notify the scheme, my lord. All previous notifications are, and the scheme is framed, my lord, under 4.1, my lord. Now, very schemes, I can only show your lordship chapter, my lord. Your lordship may not be required to look into these schemes minutely because it is only in respect of whether the scheme has been notified or not, my lord. Your lordship will have commencement of the application, 1, 2, nature of scheme, 3, definition, my lord. 4, the governance structure at page 118, my lord. Constitution of Board of Trustees, my lord. The 3, your lordship will have the scheme says board shall consist of following members, my lord. The total shall be 14, my lord. These are the role of judiciary responsibility of the board, power and function of the board, my lord. The functions: chief executive officer of secretariat, relationship with the state government, legal protection, subscriber and contribution, my lord. Structure of subscriber account, return of the statement, register, inspection, investment of fund, my lord. This is a detailed scheme framed by the government, which was duly notified, my lord, at your lordship has at seen at and then at page 131, my lord. That. So after notification, my lord, the rules page 131 to 136, various forms are there, which the employees and everybody is required to fill and implement it, my lord. So my first submission is, my lord, that scheme has been framed in terms of the order of the Honorable Supreme Court and in terms of rule section 4.1 of the Act.
Yes.
So therefore, now no grievance so far as writ petition is concerned survives because remand order was confined to the fact whether scheme has been notified or not. My first submission, my lord, is that scheme has been notified. There is no dispute about the notification of the scheme, my lord. Now, second aspect, your lordship has the dispute is that the scheme is not correct, scheme is not proper, scheme is not properly framed. All these disputes cannot come within the ambit of the present writ petition, my lord. If my friend has the other disputes, he can raise those grievances that it is not in terms of for section 4.1 of the Act or other provisions of the Act. That is also not a case. But my lord, what is going to be the nature of this scheme? It is to be framed under section 4 by the state government because that mandate or authority has been given to the state by the legislature, my lord. So that there is no dispute, my lord. Now 4.1 also 6 also I have shown, my lord. It says that it can be modified time to time by state government by issuing various notifications time to time, my lord. That also I have seen, my lord. So, my lord, one thing your lordship may have it because 4.1 and 6 has been placed before your lordship. Page 4 again. I also page 4 for a moment, my lord. This scheme under the Act, Centralized Provident Act, page 4, my lord, section 4.1.
Yes.
The state government may by notification 4.1, your lordship, page 4.
Yes.
In the official gazette, frame a scheme to be called so and so scheme to be administered by Board of Trustees to be constituted by state government under this scheme. Board of Trustees are also required to be constituted. A scheme framed under the provisions of subsection 1 may provide for any of these in the schedule, my lord. Lordship have schedule also, my lord, at page 7. Schedule is at page 7, my lord, of the Act.
Yes.
Schedule 4.1, my lord. The constitution of Board of Trustees with 4 nominees of government of whom one shall be chairperson. The 5 representatives of employees of whom at least one shall be aided college, secondary schools and elementary school. 1 person having special knowledge in banking investment to be nominated by government, my lord. The appointment of officers, etc. So the schedule in terms of section 4.1 may or may not be followed to the fullest, my lord. Kindly see section 4 again. 4.2, my lord, section 4.2. Because one of the grievances is that the Board of Trustees are in more than 11 or 12 or 13, my lord, because the schedule does not put a cap that board of trustees will be 12 or 13. The schedule only illustrates that you have 5 from the government, 4 from the employees. These are the minimum threshold you have to meet. Now, if your lordship will see 4.2, my lord, of this section, a scheme framed under the provisions of subsection 1 may provide for all or any of the matters specified in the schedule. So schedule is not a mandatory requirement. Schedule is required to be followed with minimum threshold, which the government has followed, my lord. But the question will not be germane to your lordship in the present petition, because question will be whether a scheme has been framed by the state government on remand as per the order of the Honorable Supreme Court. If there is a lacuna, defect, omission in the scheme, that may be subject matter of separate petition, where the party will have the pleading before your lordship, prayer to strike down the scheme, or saying that this part of the scheme is offending this part of the act. I will have opportunity to rebut it, but this writ petition, my lord, per se, when the remand is confined, to issue whether a scheme has been notified or not. This is one part of my submission, my lord. Second part of my submission is, my lord, that the issue arose time to time with regard to constitution of trustees, my lord, because the composition of trustees have been changed time to time. That power, and therefore that has also been objected to in the miscellaneous application by the client of my learned friend. My lord, kindly have page 41 regarding board of trustees, my lord. Sorry, page 41. Yes, my lord. This is the on remand matter, my lord. Your lordship will remember on remand. This in 24th August.
Where are you reading from?
Page 41.
This copy which next here it's not legible.
Well, not legible, my lord. Your lordship may not be required to go in detail, but that is also annexed in the writ petition. I'll place that legible also.
Yes.
I'm not.
It's there in our compilation.
Yes, it is there.
No, I'll just give the page number.
Only your lordship note down the date that the board of trustees were constituted on 16th June 2023 at the top of the page 41.
16 June.
And the board of trustees consisted of
Well, it's at page
11
June.
members.
Page 34 of our compilation.
16/6/23.
Yes, my lord. Only 16th June 2023. Your lord.
Well, that's a page number. Well, it's 34 of our compilation.
Yes.
Eligible copy, my lord, that may not be required, my lord. 16 June 2023 is the date your lordship will see.
Okay.
And your lordship will also notice that there are 11 members, including the applicant who is at serial number 9 before your lordship. Serial number 9 in this notification, he was also member of the board of trustees, my lord. Serial number Prashant Sarleka. He is applicant before your lordship in the miscellaneous application. Now, your lordship will kindly have now page 112, my lord. Yes, this was notified by the government, my lord, and now kindly have page 112. Reconstitution has taken place, my lord, second time. The membership increased to 14, my lord. Board of trustees.
Do your first NCT.
Yes.
Then, my lord, the third reconstitution is at 114, my lord. It was expanded to 20, my lord. And then your lordship has seen that board of trustees were on 18th March 2026. The notification your lordship has already seen on the next page, which I have taken your lordship. Then 129, my lord.
The orders. There's another compilation of the orders.
Board of trustees were again reconstituted on the objection that it can't be so widely bodied. So it was 129.
So
Board of
there
trustees
were 4 exercises conducted for
yes.
constitutional BOT.
Yes, sir. Your Lordship is right. 4 exercises were done by the government in constitution of the Board of Trustees based on various objections time to time, considering the point, my lord. Now, the submission which I have, my lord, before your Lordship,
Yes.
that under the Act, my lord, the scheme has been notified. Your Lordship has seen 4.1. Scheme has been notified. The Act also says, my lord, that Board of Trustees will be constituted by the state government, and minimum threshold will be of so and so person, my lord. These two stipulations, Lordship will have to keep in mind the order of remand. Order of remand was whether the Act of 1969 is being implemented by the state government or not.
Yes.
That was the import of the exercise which this honorable court, in my humble submission, is required to carry out, whether the scheme has been notified and the act has been implemented or not. 6, my lord, section 6 empowers the state government to modify the scheme and the Board of Trustees, because power to constitute the Board of Trustees is vested with the state government, my lord, under the Act. So these two exercises have been carried out. Now the objection which my friend is raising, my lord, based on some interim orders passed by this honorable court, where this honorable court did not adjudicate the issues between the parties. It was based on some of the submissions, my lord. I will place those orders one by one, my lord. Now your lordship will have the order, my lord, which are starting from, yes, my lord. So the orders are starting, my lord, at page 43, my lord.
Our compilation.
Yes, my lord, my compilation.
Very good. Yes.
Page 43, my lord. Order dated 22/3/2023. Your lordship has the order, my lord. Some middle ground may have already been found, and the state submit that it is in the process of preparing a scheme which should be acceptable to the petitioner association, and we have submitted a notification of any scheme would cover sufficient ground, but the major issue will be the teachers who have been serviced for long who lose out. Association, if the draft scheme is prepared by scheme forwarded to the association input may be acceptable to the state. Since the state readily accepts the suggestion, the state requests this draft scheme to be made over to the advocate for petitioner for within 4 weeks, whereupon associations will communicate the office of etc. My lord. Next order at page 45, my lord. Your lordship has 22nd March 23. Next order is page 45.
Yes.
The your lordship board of the next order of 31st May records that the board of that 29th May notification which I have placed before your lordship has been 29th May notification regarding constitution of board of trustees, my lord. So this
Yes.
was noted by this honorable court at page 47, my lord. 47, my lord. On 6th September, it is submitted on behalf of the state that pursuant to creation of trust in terms of order of Supreme Court, draft rules have been prepared. A copy of draft rules have been handed over to the advocates. My lord, it was handed over, my lord. Then, my lord, lordship will skip that gadget notification of the 52 is the draft scheme, my lord. 52 is the draft scheme.
Right.
52 to 85 draft schemes are there. Then minutes is there. Then your lordship will come to the orders of this honorable court at page 106. Because they have also filed a contempt, my lord. Contempt also of, I don't know, of 106, my lord. At 5/11/2024. So details of the scheme and some of the aspects of the scheme are noted by this honorable court in the interim order, my lord. Various aspects of the implementation part of the order is noted by this honorable court, my lord. Then at 109, my lord. 109, my lord. This on after hearing we observe that direct as follows. Board of Trustees for the Centralized Provident Fund scheme has been reconstituted on 24 May 2025. New pension scheme covering joint so and so finalized. Said scheme will be presented to board, which will be approved the pension scheme, which will be portfolio manager and so and so. The list on so and so. My lord, the implementation aspect. Now 110, my lord. Affidavit filed, Mr. Khan, London Council and Portfolio Manager has been appointed. Now in 111, my lord, paragraph 4, we directed complete finalization of scheme, notify pension scheme positively within 4 weeks, my lord. Then, my lord, the entire then scheme was notified, my lord. The board was reconstituted, my lord, and we are at that stage now. At this stage, my lord, the objection was filed, which is subject matter of lordship's hearing, my lord. Objection was filed by my learned friend, my lord. If your lordship will have the objection,
Keeping on filing this affidavit,
because it is dated 2nd April 2026, my lord. 2nd April 2026.
Where's the objection? You have muted yourself.
Sorry, to 2nd April, this is objection dated 2nd April 2026.
Where is that?
My lord, this is the, because the entire argument of my friend is based on the objection only, not on the main writ petition.
2nd April 25.
26, my lord.
26.
2/4/2026. Yes.
Where's that objection? Okay.
from the status reports that were been filed. And the draft scheme is dated.
Your Lordship has the objection,
Yes.
which is objection filed.
I thought must have noted.
Lordship, page 1, my lord.
To notification 18/3/2026.
Yes, my lord. Objection to the notification. I have placed the notification, my lord. The scheme,
Yes.
which is at chapter 16, which is now the objection is to the various aspects of the scheme, my lord. Now kindly see the whether in the existing writ petition they can file the application. This is objection. I don't know, my lord, how under which provision they could have filed it also, my lord. But be as it may, my lord, your lordship may see the. Now what is the objection, my lord? I briefly placed the objection also, my lord. Now paragraph 4, if your lordship will have. Paragraph 3, my lord. Do you say?
Para 3.
3, my lord, at page
Do
2.
not have a copy.
Yes, page para 3, page 2, my lord. Petitioners, though through this affidavit, are putting forth following objection to the Meghalaya so-and-so notification void 18(3), which are in absolute violation of Parent Act and others direction passed by the Honorable Court, my lord. Kindly mark, my lord. This is now a new chapter
Oh, yes.
giving rise to
That
fresh cause of action. In the existing writ petition, there is no scope, my lord. A lordship has already noted that writ petition cannot be expanded for every new cause of action. Be as it, my lord. Now, my lord, the preamble is quoted, my lord, on next page, my lord. Then various provisions of the act is quoted. I couldn't find out what is the exactly. Now, a lordship will find at page 6, my lord. Page 6 bottom, the bullet point where some objection. In fact, page 6, bottom, my lord, running pages and bottom, my lord. 6. In view of the provisions of the top, my lord,
Page 6.
under the clause total, page
However,
6, my lord, and no, my lord, your lordship, kindly see
in
the
view
top from
from top.
beginning only, from the top of the page only, my lord. In view of the provisions stipulated in section 4 of the MPF Act and schedule appended thereto, specifically under clause 1, total strength of board is to 10 only. So first thing is they say it should be 10 only. It can't go beyond 10, my lord. However, in absolute contravention of the Act, the stipulated for contrary cap of 10 members. So they say that they are reading cap into the schedule and say that it is beyond. The first trustees of the board was constituted so and so, my lord. However, respondent reconstituted the board of trustees. What has happened, my lord, that the applicant is no longer part of the signatory of the affidavit is not no longer part of the trustee. That could be possible reason for raising the objection, my lord. Then, my lord, 4.3, there are various aspects of the scheme which have been questioned here, my lord. And those have been exhaustively replied in my reply, my lord. If your lordship will have my counter affidavit, I'm not troubling your lordship because this will require separate adjudication apart from the writ petition, my lord. Whether a scheme is in accordance with the provisions are in accordance with the Act. In my humble submission, a scheme has to be framed by the state government. That is the requirement of law. That
And the
scheme
Act
has been
allows us
framed.
flexibility with regard to
Yes,
may
yes,
or
yes, my
shall
lord.
or
Now, but on merit also, I have to satisfy your lordship on the merit also, my lord. But that may, in my humble submission, in my kindly have my reply, my lord. Each and every aspect I have covered in my reply, my lord. First objection which I have raised at page 3, my lord, of my counter, and
yes,
more particularly paragraph 8, my lord,
yes.
where I said in the last line of my paragraph, paragraph 12 of the said order defines the scope and purpose of remand in crystalline precision, my lord. My lord, I have quoted that, and my submission is that it is going beyond the scope of the remand order, whatever is being prayed, my lord. That is my submission, and I refer to the judgment, my lord, in paragraph 12 of one of the recent judgment of the Honorable Supreme Court on this aspect, my lord. That I have copy also, my lord. I will place that copy also separately, my lord. Paragraph 12 will also have paragraph 12. In Shiva Sankara versus HP Veda Vasya Cha, in 2023 13 SSC, where it was held that court acting on remand cannot go beyond what is stated in the remand order. That court's jurisdiction is coextensive with the order of remand. The relevant portion of judgment is extracted hereunder. Before proceeding with the matter further, we think it appropriate to consider the impact of such an order of remand, as it would certainly deconvolute the consideration of this appeal. There can be no doubt with respect to the settled position that court to which the case is remanded has to comply with the order of remand, and acting contrary to the order of remand is contrary to law. The order of remand has to be followed in the true spirit. My humble submission is, my lord, what my friend is asking for is seeking, my lord, is beyond the remand order, my lord, beyond the remand order, which is not permissible in my humble. Remand order is confined to two aspects, whether scheme has been notified and board of trustees have been constituted. Now, my lord, kindly have the page, my page, my lord, page 6, my lord. Page 6, my lord, bottom. Challenge is infructuous and no surviving prejudice subsists, my lord. 16, my lord, on next page. I refer to the notifications issued time to time, my lord, and the various aspects of the scheme, my lord. I can then, my lord, on the detail of the scheme, and if your lordship will come to the structure of the scheme at page 15, my lord, page 15 of the counter affidavit, my lord, I deal with the objection on merit also. Lordship intend to go into the merit, my lord, I will place, because it was not argued as such in detail. But I have in my counter affidavit, my lord, at page 15.
1-5.
15, my lord, structure of the scheme. I have stated structure of the scheme, my lord. Then, my lord, then, my lord, on page 19, composition of board of trustees, my lord. Then, my lord, 22, your lordship will find investment framework, my lord.
Functioning of board of trustees.
Then, my lord, and 25, you lordship will find record keeping and returns, my lord.
Yes.
And then, my lord, on 28, you lordship will find contribution rates.
That is, where are the functions?
And then 30, retirement benefits and annuity. Retirement benefits and annuity. So I have, my lord, addressed the issue on merit also, my lord. And the prayer, if your lordship will come to the, because the application cannot expand the scope of the writ petition, my lord. It is a settled law that application is not reservoir of all new cause of action. If your lordship will see the prayer of in the application, my lord. No, it's not even application, it's an objection to the scheme, my lord. Page 18, paragraph 18 of the objection, my lord.
Not the bylaws. Not this, the scheme. With the schedule to the scheme. Until the periodic. In the bylaws. And it's marked by me. Turn the next page.
Page 18.
Sorry, paragraph 18 at page, my lord, running page is 24, bottom 23, 24, your lordship,
Yes.
where in view of the foregoing grounds, my lord, objections made herein, the notification dated 18th March 26, whereby government has
Give me the
notified,
present affidavit.
being bad in law, absolute contravention of the act, and orders and direction passed by court is liable to be quashed and set aside by the honorable court, my lord. So the prayer is to quash this scheme, my lord.
What is it?
And then the ball will be set to, the clock will be turned back to the zero, my lord, saying that the scheme per se is violative. If my friend has grievance with regard to aspects of the scheme, he can very well prefer, my lord, I am not having any objection and I can't take away his right to challenge this scheme by way of appropriate writ petition, which we will meet by filing proper counter affidavit, my lord. Law, my lord, recently, in fact, if a lordship will, I have already placed that law is settled on this aspect, my lord, that the prayer or the party cannot go beyond what initially is prayed, my lord. The first judgment, my lord, is I rely on, my lord, 2024 SC online SC 3677. My colleague is having copy, my lord. That is Ajay Kumar Jain.
Can get the right. Yes.
My lord, paragraph 13, 14, my lord. These miscellaneous applications, which are being filed on daily basis, have something to do with a fresh cause of action that might have arisen with a very remote connection with the main proceeding. No miscellaneous application is maintainable in writ petition to revive proceeding in respect of subsequent events. So that is my first submission, my lord. Second submission, my lord, is the second judgment, my lord, is very brief judgment, 2021-19 SCC 758.
In your objection, you have made a prayer. Thanks.
Paragraph 10, my lord. Having heard the learned counsels for the parties, paragraph 10, my lord, considering the facts of the case, we are of the clear opinion that since they were neither pleading nor any prayer with regard to playing of music of DJ or public direction of the High Court as quoted here with regard to noise, DG and restriction of playing cannot be justified. Writ petition having been filed for a particular cause with a particular prayer cannot be expanded to cover within its ambit all issues which may be of general or public importance without there being any pleading or prayer with regard to a particular issue. In our view, no such direction been issued, especially in a private litigation which was not in favor of public litigation. We say so particularly because prior to passing order, etc. My lord. So the submission, my lord, is based on this that it cannot be expanded. Similarly, my lord, recently also in MC Mehta, your lordship is aware that thousands of miscellaneous applications were being filed time to time by the Honorable Supreme Court. In recently, my lord, those IAs have been closed by saying that you can prefer, my lord, that is 2026 SSC Online SC 6th, paragraph 11. Paragraph 11, one line, only one in paragraph 11, my lord. One line, my lord, because those IAs, your lordship is aware that oldest pending case in Supreme Court, my lord. Paragraph 11,
But
my lord.
they've closed this mother case, this 85 case has been closed.
Oh, yes, my lord.
Gonda Varman is the same thing.
No, it's
see,
not.
all like in
Same
Gonda
thing.
Varman, whatever happens that whatever developments are there, IAs are filed and issues
My
are
lord,
addressed.
It's still
very
pending,
positive
Milord.
development, my lord. That has also been, my lord. Kindly have paragraph 11, my lord. The observation which I am drawing your lordship's kind intention, my lord. Paragraph 11,
Yes.
last line of paragraph 11. In our considered opinion, permitting present system of ever increasing IAs to continue would be against interest
Where
of
reading from?
judicial
Para
efficiency.
11.
Para 11 last line.
Okay.
last,
Okay. In
the
our
last
considered,
line
yes.
of para 11. In
Okay,
our
yeah.
considered opinion, permitting the present system of ever increasing IAs to continue would be against the interest of judicial efficiency.
Please read
Lord.
entire para 11.
So this will be also, and Lord, one page order of Justice M.R. Shah, my Lord, one page, only to show that consistently, my Lord, a Lordship has one page order of Justice Air Captain G.S. Bindra, my Lord. Apart from the fact that relief which is sought in the present application by way of interim application cannot be granted, even the relief sought is beyond the scope of the main writ petition before the High Court, and expanding the scope of controversy in one application has been dismissed by the court. My lord, so the relief, what court says that you cannot expand the scope of writ petition by filing repeated IAs time to time. So my submission, my lord, is
Where is that? After the draft scheme, you told him, where is the
the petitioner has no pleading in the entire writ petition. The entire application is basically disguised or a form of new writ petition, my lord, a fresh writ petition disguised in objection affidavit where prayer is also there, my lord. The remand which was there, my lord, whether the government is implementing 1969 Act or a scheme has been notified or not, that your lordship has overseen time to time. We have notified the scheme. We have constituted the board of trustees time to time. Therefore, my lord, this objection and writ both, in my humble submission, do not survive, and they should be closed, my lord.
Yes.
That is all I have to submit. my lord.
Mr. Paul, you make a reply on Tuesday because we are a bit.
let it be next Thursday. This Tuesday we'll have some.
Thursday is?
I'll have some personal
If
difficulty.
you kindly, yes, and you
Thursday.
can bring your notes also.
Let's-
Both a bit fatigued also.
We are ourselves fatigued because I am lost in papers. I'm
Lots of papers lost because hardly we sleep last night.
well, it's
But that
is
consideration.
the messy magic still working?
Exactly. So we have to at least see.
My advocate general is not with me on this page. Melits.
On Messi's page. Let's for further hearing on it. Thursday is the 6th. It's the 23rd.
23rd. Melits.
2. Item number 2.
Part 2, 1 and 2 are connected.
Two was mentioned, my lord. Two was mentioned, and it was adjourned, my lord, on after 3 weeks.
I'm appearing.
Let's 2 is the connected.
Let's together.
Connected but.
Supplementary list item number 3.
May it please your lordships, I'm praying for some accommodation, Lordship. The learned DSG is currently on
At
next
end of the
court.
board.
Accommodation, Lordship.
Tuesday,
Then
like after 1 week, yes.
21,
21, yes.
Lordship,
On the prayer.
this item number 3, it's connected with item number 5 and 6 from
5
the
and
daily
6
list,
also.
Lordship.
Of the main list.
Of the main list, a daily list.
Main list on 21st. This
of-
matter is regarding that income tax
No, GST matter.
or GST matter.
GST matter. So 5 and 6 of the daily list should also come along with.
Daily list and this one.
And this will be the lead case. Long day.
Very good.
Daily list item number 3.
So, Nora. See, Nora. This one.
I'm for the appellant, my lord.
Yes.
This matter, my lord, the EC has, my lord, decided to restore him, my lord. He has approached the EC members.
Where is the order? Where is the order of reinstatement?
No, my lord, that is what, my lord. We are yet to pass a formal order. So what I was instructed.
Will you just take down Mr. S. D. Submit
So
instruction?
I want to place on record, my lord, the order. Let the order come, my lord.
Yes,
Because
no.
this was only
It submits that the matter has since been considered by the appellants, right? And the reinstatement of the petitioner has been agreed upon. However, formal orders.
Till now, the formal order has not yet come out, my lord.
But however,
We are
formal
waiting for the formal.
at least after 3 weeks.
My
So
lord.
wait for the developments.
My lord.
Item number 4.
Phosphorus Lordship.
Yeah. Yes, Dr. Saraf.
Commission of Taxes, Meghalaya, my lord, rejecting the claim of the some relevant facts, my lord. And also you'll find, my lord, that
22. Yeah. Yes. Yes, Dr. Saraf.
The Meghalaya Cement Sales Act 2010, my lord, which was passed by the state legislature, was declared to be ultra-vires and beyond the powers of the state legislature
Yes.
by the judgment and order, my lord, which you also find at page 59.
Page 59.
59.
Yes. It's been repealed, the act.
My lord, the act was repealed by the GST, my lord, when after the introduction of the GST, and this is prior to the period of the repealing of the GST, this Sales Act, my lord.
Yes. Yes.
Now here you'll also find the at page what they say
59.
59 it starts, my lord, and you'll also find the relevant part at page 5 para, my lord, 15 64 page 64
Yes.
you also find accordingly WPC number so and so are disposed of by holding that the state has no authority to impose cess in terms of the Impugned Act of 2010, and by annulling the act as ultra-vires, the Constitution, and requiring the state to refund 20% of the amount realized on the such count from the individuals petitioner to the such petitioner and investing 30% of the total amount of cess realized from the such legislation for the purpose of procuring the equipment or the life cancer saving of the government general hospital general hospital, my lord, and well, just a minute, my lord. General hospital under the so and so procuring the government petitioner owing to the competent general hospital in the Shillong so and so. Since the refund directed to be made by the petitioner appears to be made after that, then sufficient, no additional order is made at cost. It is unlikely event that the refund affidavit of the chief secretary is not received by the department within the time directed. The department shall bring the matter to the notice of the court for appropriate action to be taken against Sagat as contained in the order of refund are confined only to the present petitioners who had challenged the act prior to it being repealed and before the GST regime came into force. So the court directed that the act to be declared to be ultra-vires and state, beyond the competence of the state legislature, and 20% was directed to be refunded to the petitioners, 30% was to be given to the cancer hospital. And it was observed, my lord, that this will be applicable only in respect of the petitioners who have filed the petition prior to the repealing of the, my lord, this cess act, that is prior to the introduction of the GST act. Now, after the
16
order passed by the, my lord, this honorable court,
16
my lord, the
prior GST is 17 June. Yes. Yes.
The petitioner submitted it, my lord, after the judgment, my lord.
No, after 22, but it's fine prior GST. That's why the intent is. This is filed on 24. Yes, Dr. Sarab.
My lord, after the judgment of this honorable court,
yeah,
my lord, the petitioner submitted representation claiming refund of the cement cess which was paid by the petitioner, my lord, and the said representation was submitted on by letter date 28/2/2022, which you also find at page 66. But that is not now, my lord, relevant for the purpose. Gave a reminder while letter date 16/9/2022, which was also not replied by the respondents. Being agreed, my lord, the petitioner filed a writ petition before this honorable court, and this honorable court, my lord, by the order dated, which you'll also find at page 72, dismiss the writ petition, my lord, by holding that you'll also find para 3 by referring to the earlier order.
Yes.
That the order was clear and unequivocal that the refund of 20% that was directed to be made by such order was to be made on to the individual petitioners out of the amounts seized from them. The refund was confined to the petitioners who has alleged that the imposition of the cess and was not for other manufacturers who had not challenged.
Yes.
So, my lord, it was dismissed on the ground that the earlier petition
did not cover your case.
That the same is not applicable.
Won't cover your case, yes. Yes.
My lord. Now, the petitioner being agreed, my lord, filed an SLP before the apex court. And the apex court, my lord.
Yes.
You'll also find at page 75. Also got it, my lord, 75.
Yes.
After hearing the learned counsel so and so submitted that the petitioner would make a suitable representation and also disclose necessary facts as to whether a separate fund on account of the was existed at the relevant time in relation to the collection of the cess. In case such representation is made, the respondent government would consider it on its merits and pass such orders as are appropriate. So, my lord, the court, in fact, the representation was made that whether the amount was a separate account was maintained in respect of the cess which was paid, and the court directed that in case such a representation is made, then the respondent shall consider the same and dispose of the same on its own merits by passing necessary orders.
Now, Dr. Saraf, just to cut short your arguments, now the thing is that after the Supreme Court order, you had approached the authorities, correct? And then they have rejected your prayer on grounds of number one, delay, on grounds of that it was prior to, you have not raised your claim before repeal, and your also the periods which you claim go back beyond more than 6 years, 2011, 2012. So that is the only thing you have to satisfy us on that. That how can you maintain your claim? Also take into account the provisions of the Meghalaya GST also, which saves the earlier.
Well, I will submit.
Yes.
Well, I submit in short.
Yes.
My lord, the act was declared to be ultra vires after the repealing of the act by the Honorable Court.
Yes.
Prior to that, there was no judgment of the Honorable Court. Now, the petitioner filed a representation for the claim of the cess amount after the judgment was delivered by this Honorable Court. Now, when we went to the Apex Court, the Apex Court directed that we submitted for the Apex Court that because the court inquired whether it was passed over the customers or not, then we submitted, my lord, that we will give all the accounts and documents to show that it was in a separate account, it was not passed over, and the court directed that if such representation is made, then it will be considered on its own merits and order will be passed. Now the court has not directed because the limitation and all the issues were considered by the division bench of this on the court, that we said that it will be applicable only in respect of the petitioners and not others who have approached the court after the repealing of the so-and-so. Now, after the Apex Court has directed that the matter should be considered on its own merits after the representation is submitted, it is not open for the respondents to go into other issues and not to go into the issue which was relevant in the context. That issue has been decided to, the documents are too far old, so it is not possible for them to verify it. Now, the documents which are there, which are with us, the respondents cannot say, my lord, that the documents cannot be verified.
No, Dr. Sorry, just come back to the Supreme Court order.
My lord.
See, make a suitable interpretation, also disclose necessary facts as to whether separate fund or account was existed at a relevant time. Now, can you show us that regarding that veriment?
No, in the representation we have given it.
No, not representation, in your representation, which you had filed before the authorities for reconsideration of your case. Where is that part with regard to whether it is disclosed there's a separate fund?
My lord, yes, my lord, I will show it, my lord.
Yes.
You'll also find in terms of the order passed at page 76.
Yes. No, you have to understand all the Supreme Court so in its correct perspective. The first time we look at this matter today. Anyway, yes. Yes.
My lord, 76 is the representation, my lord.
Yes.
And you'll also find in the, I'll take you to lordship the relevant part, my lord. Earlier part is all, my lord, the factual part.
Yes.
And also may say decision of the Supreme Court at page 79, which I referred to.
Yes.
Now, you'll also may clearly see that later part, if any cess has been collected in violation of the law by the state, this is only discussion of the law point, my lord.
Yes.
And I will take you also to the relevant part.
Where's the fund?
My lord. I will just take your lordship.
Because if we understand correctly, the purport or the import of
My
the
lord.
Supreme Court orders that if it's a fund, then maybe there'll be a question of some refund.
My
If-
lord.
Yes.
Fund
You might be wrong.
means-
You might be wrong, but if the fund is kept separate, then maybe from that fund.
My lord, the funds means, my lord, it has not been passed over. Your lordship, can you see para 4.0?
No. We can't come to incidents. We just taking ourselves to the order of the Supreme Court. That's all.
Order of the Supreme
Whether a
Court,
separate
I
fund
don't
or
know.
account existed at a relevant time in relation to action. Whether state government had.
Your lordship, see para 4.4, my lord.
Yes.
Second paragraph, my lord. Further, the cement says payable was always reflected in a separate and independent account head in the books of account of the petitioner, my lord. On examination of the books of account of the so-and-so, it will be apparent that there is no connection between the ledger of the cement sales payable with the various customers to whom the cement was sold. In other words, there was no record of any cement sales that was recoverable from the customers as per the books of account of the DCL. Accordingly, it cannot be in any manner be considered that the incidence of the tax has been passed over to the customers and that the doctrine on just judgment would be applicable. In support of the matter, the same decision is enclosing with a copy of the certificate issued by the independent chartered accountant as annexure so-and-so, copies of the relevant extract of the audited profit and loss account, audited balance sheet, and the simple ledger account of the sales account for the relevant assessment year are collectively annexed and so-and-so. So I have annexed the ledger account where the cement sales was separately shown, the profit and loss account, the balance sheet, etc., everything to show that it was in a separate ledger, it was never passed over. Now this issue had not been considered by the commissioner at all.
He has come to that. He has not dealt with that.
No. You also kindly see the order
Yes.
at page 84.
Yes.
This is the order, my lord. And I will take your lordship to earlier the legal points have been made, but I will take your lordship directly to the relevant part where, my lord, at para, my lord, 13. It is also not in dispute that in the instant case, representation you have sought refund of the cement sales for the period commencing from so-and-so to so-and-so. The verification of the documents as to whether the sales has been passed over to the customer or it has been aforesaid on the documents and would not be feasible at this stage. Therefore, this is also an additional ground to reject your claim. So it has not been verified at all. It says that it is not feasible. My lord, it is my account. How the commissioner can say that it is not feasible at all to verify it?
Yes.
They are only going on the issue, my lord, that the question of the limitation, the question of this, the act was refilled, and they say that in the GST Act, the collection was saved. My lord, the collection of in the GST Act, in the saving clause, the illegal collection and unauthorized collection is not saved. Whatever action has been taken earlier, the earlier act, is saved subject to the condition, my lord, that is not ultra vires. If it is ultra vires, this honorable court could not have passed a direction for refund of the amount if that is saved. Because, my lord, any act which is declared to be ultra vires is deemed to be that act has not existed in the statute book from the very beginning. So the question of saving of the actions taken under this act declared to be ultra vires does not arise. Now, the direction of the Supreme Court was that you give a representation showing that it is a separate account, it was kept, meaning thereby it was not passed over to customers, and the respondent will examine it in on merits and thereafter pass an order. Instead of passing an order on that issue, they have gone into all other issues which are not relevant in the context. They are saying that the division bench judgment has been there and that has not been reversed by the Supreme Court. Well, in spite of the judgment of this Honorable Court, the Supreme Court has given a particular direction. Now, can it be said, my lord, that that direction of the Supreme Court has no meaning because the division bench judgment has not been reversed? In spite of the division bench judgment, the Supreme Court has given a particular direction and it has to be followed. They cannot say.
No, but they have not distinguished. They have not. The judgment was placed. Was this judgment or division bench placed when this matter was taken up before the Supreme Court?
Well, that was under challenge, my lord.
23.
That judgment was under challenge.
You challenged the later judgment, not the main judgment, correct? Was it brought under notice? Yeah, but it's not discussed at all. Yes. So the impugned fine judgment was that it's your case only.
My lord, it says, my lord, that it will be applicable only in respect of the petitioners.
The parties,
who were
yes.
there.
Yes.
Parties were there. Now that was for the judgment, and following that, my case was there. All which were part of the SLP. Because my case was dismissed on the basis of the earlier judgment, that was a part of the judgment.
But there's even then this one also the order of for due respect.
Well, if it is said that the division bench judgment has not been reversed and thereby means, then this order has no meaning.
With due respect also, Dr. Saraf, the order of Supreme Court also is absolutely vague.
My lord, what I can do, my lord, that the Supreme Court, after all, the Supreme
final.
Court, whatever the order they pass.
Yes, because it says that in case that was made, the respondent should concern merits. On merits means merits to do an entire scope, or only merits with regard to your separate fund. What is the? That is, you would like have to assist us. So what will be the purport of the? So whether what merits would mean the entire matter will
not only entire, my lord, the court in fact wanted to say that whether it has been passed over to the customers or not, for that you will give a recourse of the representation.
But does not reflected here in the order.
My lord, you will also find that in the Supreme Court's order SLP dismissed.
Yeah. Yeah. Where's the copy to SLP? You haven't retrieved it,
Well, SLP copy is not here, but if you also ask me that I can file it.
Yes, just for our own satisfaction, you kindly file a copy.
No, certainly, my lord, because I appeared, it was everything was there.
Yes.
And your lordship is very correct, my lord, to say, my lord, that the order is little vague.
Not clear. I will say that it's not clear because you see, what's the scope? What will be the scope? For even the authorities to consider.
My lord, whenever the SLPs are filed, orders are passed. This is the type of the order, my lord, which the Supreme Court passes.
So even to what you call crystallize your relief also for the court to examine also.
The High Court passes the order with a speaking order detail, and you'll also find when the interim stay is granted, they only say stay. Now, what stay is there, nobody knows. Interim stay. Now, interim stay may mean anything, but that's why it is Supreme Court, my lord.
Yes, we'll list some other matter. You can just for a court satisfaction.
Well, I will do one thing, my lord.
Yes.
I will do one thing, my lord. I will file the SLP copy along with the one affidavit with a direction as directed by your lordship, before your lordship. So your lordship will come to know, my lord, that what were the contents and what were the next.
Only for satisfaction, not really. You won't be part of the record.
Yes, yes.
Per se. It's just that we'll just say list the matter of further hearing when.
My lord, I will just take the copy.
So the date. This when?
After 3-4 weeks, my lord. 3 weeks.
After 3 weeks, yes. As it is found that the no, this is, the learned counsel for the petitions are permitted to produce a copy of the SLP file before the Honorable Supreme Court in this regard. Yes. Yes, accordingly and so on. So yeah. Just was
Yes,
to.
I will file along with the additional affidavit, my lord. You could produce.
No. Just the
Because that will
SLP
have
copy. Only the bare SLP. Nothing else. Yes.
As you see, please. No, as you see, please.
Item number 7.
Who's appearing?
My lord,
7 is Xeon machines.
John Mason.
What is
Actually related this
counsel
to-
change again?
No,
Then
from the beginning I am there, actually due to some, I am sending you
substitute in the meanwhile and come back. You're not pressing your prayer for the.
miscellaneous we are not pressing, we are hiring, mail.
Then we'll have it on when? You're seeking time.
Yes, Your Lordship.
After 2 weeks.
Yes, I know.
Yes. On the prayer made by MSC Jara due to unavailability of GI this after 2 weeks. Yes. Then-
Any mention?
May I please, Your Lordship?
Yeah.
Your Lordship, I beg to mention item number 152, Your Lordship. The conducting counsel, Ms. T. Yangi, is on sanction leave, Your Lordship.
152.
Yes, Your Lordship.
No objections, Your Lordship.
Shemi Shilla.
Yes, Your Lordship.
No urgency. Okay, yes. Just 2 weeks.
Much obliged, Lordship.
Yes.
May it please your Lordship. Lordship, I beg to mention item number 140. Mr. B. Pathak is unwell.
Yes, MS. Emmer Chung. Oh, yeah, sorry, yeah, here. Yes. On request for 2 weeks, yes. Yes. Make it quick, yes.
May I please, Your Lordship? I beg to mention item number 146, Your Lordship. It's a joint request, Your Lordship. Lordship, joint request.
Yeah, objection?
Joint request, Your Lordship.
Okay, and the prayer of the parties is of 2 weeks, yes.
Highly request, Lordship.
Lordship, I beg to mention item number 141, Lordship. Lordship, after 2 weeks, Lordship.
You're there?
Objection, yes, Lordship. After the state, madam. No objection.
Obliged, Lordship.
Deeply obliged, Your Lordship.
May I please, my lord? I beg to mention item number 153, my lord. 153. I'm praying for time, my lord.
The last matter.
Regularization of a sweeper, Lordship. Lordship may observe that they have asked for time 3 times. This will be the 4th time. If
All right. Yes. Yes.
Highly
wait for
Supplementary list item number 1.
May it please, Your Lordship. My Lord, this is a legal aid matter, my Lord.
It's
a legal aid matter, my Lord. The petitioner herein, my Lord, has approached...
Legal aid matter?
Yes, my Lord.
Yes.
The petitioner herein, my Lord, she has approached the respondent number 1, my Lord, to provide her a marriage certificate, my Lord. But the respondent number 1 did not provide her the marriage certificate, my Lord. The respondent number 1 is a temple, my Lord.
Then how can a issue as a temple?
My Lord, the respondent number 1 is also registered, is a registered temple, my Lord. So, and we had filed an application to respondent number 2.
Certificate from a temple. You got married in a temple?
We were married in the temple, my Lord.
No other, except temple marriage, no other marriage.
No other marriage, my Lord. Temple marriage, and at that point of time, they provided a marriage certificate, like a receipt, my Lord, where all the details is written there. So, my Lord, at that point of time, I had the marriage certificate previously, my Lord, but because the petitioner herein had some litigation with her husband, so she kept those documents in the bar, my Lord, which got down into fire. So she asked the temple to provide her marriage certificate, and she had filed a representation also, my Lord. But then the temple also said, directed the petitioner to bring her husband along with the 2 witnesses also, my Lord. They never said that they won't give. They said they'll give, but then now she is in dispute with her husband, my Lord. So husband.
No, but only one thing.
Yes, my Lord.
How can? But then do they maintain records?
My lords, regarding that, they have said that they will issue. They said that because I have the photographs, my lord, of my marriage also, which was solemnized in that temple before.
Issue mandamus to a temple, yes. Yes.
So, Your Lordship, I am for the respondent number 2 only. So,
2?
Yes, my lord, because the temple is registered under the respondent number 2, and we had filed a representation to the respondent number 2 to direct the temple to issue the marriage certificate, a duplicate copy at least, my lord.
Notice on behalf of respondent number 2, Your Lordship, without instruction.
Also, what relief? You have some other proceedings against your husband?
My lord, yes, my lord. There are many cases before the trial court.
For dissolution of marriage, yours.
Not only that, my lord, but there are also other cases, my lord.
What other cases?
My lord, because her husband, my lord, the petitioner husband, has also filed many cases like defamation and all those cases questioning the validity of the marriage, my lord. That's the reason why the petitioner has approached this court, my lord.
You filed for divorce?
we had filed before for mutual divorce, my lord, but then that could not happen because of
Any issues?
there were some issues, my
No,
lord.
no, issues, I mean children.
Children are there, yes, my lord. There are 2 children, my lord. The birth certificate is also annexed here.
Issue notice, I don't know what will come out of it, but anyway, I heard MSS now say, issue notice, MS as per Saji, the GA is present behalf on number 2. No further notice on the said respondent was issued to remain respondent within 3 days. That's out of 3 weeks.
Obliged, my lord.
Item number 2.
Yes, Mr. Siddiqui.
I'm doing for the trivial benefit. For last 2 years, he has not got pension or
Trivial benefits? When she retired?
Yes, sir.
When she retired?
Died in harness. Died in harness.
Her husband died in harness.
Yes.
Yes, heard Mr. A. Siddiqui, Senior Counsel assisted by so and so issue notice. MS Saji, LG accepted on behalf of all
1
the
and 2.
respondents. No further notice required. Just after 3 weeks, yes. For substance affidavit. Yes.
Much obliged.
3.
Your Lordship, I would like to withdraw this repetition. We will liberty to file fresh. Withdraw this repetition. We will liberty to file fresh.
Where's the repeat coming? Where's the repeat coming? I think the switch off. Switch off.
Only item number 3. Only item number 3.
Yes, Mr. Q not raised that without to withdraw instant matter. How will it be filed a place to advise stop? Number 3 is allowed. 320. Matter stands dismissed or withdrawn. How will liberty as parade? Yes.
Item number 4.
May it please your Lordship.
Yes.
It's always been a pleasure for making submissions before this honorable court.
Yes.
This by way of this writ petitions, my lord.
Yes.
It is a matter regarding, my lord, this Meghalaya Cricket Association. May I take
pending the petition?
Yes, I will come to that. That is the next matter, my lord. Here, my lord, will kindly come to page 19 directly, my lord.
Are the prayers not overlapping?
No, my lord, because my submission with regard to that case, because an interim order has been obtained, and according to me, my concise says it has been obtained by suppression. Page 19, my lord, will kindly see. Member of the Apex Council of Meghalaya, so and so. This is dated 3rd March 2026, issued by Honorary Secretary, my lord. The agendas of the meeting. These are the agendas with regard to the this conveying of this particular meeting,
Yes.
which has been fixed on 7th of March. Now, my lord, will kindly come to 7th of March, minute at page 20. Now, my lord, will kindly see these were the persons present. It's been stated out there. Item number, agenda item number 2. This is very important, my lord, will kindly see.
Yeah.
The Apex Council noted that the position of Ombudsman has been vacant since 24-25 and that the constitutional requirement mandate the post to be filled up as soon as possible. The President reported that pursuant to the mandate given to the previous Apex Council meeting, a due search was conducted and Justice so-and-so of Guwahati High Court had consented to take up this role. The President noted that so-and-so has previously worked in Meghalaya on various assignments and is a resident of Guwahati, making him geographically proximate. Sri so-and-so inquired about the honorarium. The President stated that the previous Ombudsman so-and-so of rupees so-and-so and proposed retaining his this amount in the interest of containing expenses. The President noted this was an establishment precedent and that the High Court judge must be treated with appropriate regard. Decision. The Council ratifies the appointment of so-and-so. Who has ratified it, my lord? The Apex Council, my lord.
Yeah.
Now, next come in, my lord, that the person that at page 24, my lord. This is again dated 7/26, my lord. Summary decisions. Second one, appointment of so-and-so of Ombudsman ratified at an honorarium of rupees so-and-so, letter to be issued in the week of March 9, 2026. Now this has been the certified copy and appointment has been made by the Apex Council. Now my lord will kindly come to page 25.
Yes.
This is very important. Now these were the persons present. The 26, if your lordship comes in, that's the primary document, wherein my lord will kindly see honorary joint secretary, no signature appears. Honorary treasurer signature doesn't appear. And my lord, I don't know about the AZ representative out here, my lord, but I don't find it. But anyway, in the next, at page 27, kindly see, my lord, that is again 726. Honorary secretary's signature is not there. Honorary joint secretary signature is not there. And other signature appears. Now, my lord will kindly come to...
One thing, now what about this attendees, which is shown at page 20?
Page 20, my lord. I'm coming.
You mean to say they attended and did not sign the minute?
No, my lord, this has been a decision taken by the Apex Council.
No.
I'll come to that, the constitution part.
You know, one thing is...
These were the agendas.
This is the 26th Apex Council meeting. I'm just trying to understand.
Yes.
Now, this attendees is shown as honorary secretary at present.
Yes, present.
Then the joint secretary. Now you say that 27
yes, that 7, my lord will kindly come to 27 page number. Not been signed. So it has not been agreed upon as such been projected. My lord will kindly come to the next, which we have challenged in this writ petition, my lord.
Yeah.
March 9, 2026.
Yeah.
Now, as per the Apex Council decision, this has been conveyed and the ombudsman was appointed. Am I clear, my lord?
Yeah.
Now, may I take your lordship directly to the constitution part, which has never been, my lord, shown to this honorable court. My lord will kindly come to page 63. This is memorandum of association, my lord will kindly see, as per judgment dated 9 August 2018 passed by Honorable Supreme Court of India. So, my lord, with regard to that Lodha committee report, and that is to be there, and on that very basis, my lord, the BCCI, my lord, with regard to their, my lord, rules regulation, it has been amended. ACA has amended. I'll show and demonstrate. And Meghalaya also amended, my lord. Now, taking to these rules, my lord will kindly come to at page 66 of the rules.
Yes.
Apex Council, what does it mean?
Which provision is it?
66A, my lord. Page 66.
Yes, got it.
Yes, interpretation of terms, it's 65. And A is the Apex Council.
Yeah.
Apex Council means the governing body appointed by the general body of members to manage the affair of the association. Am I clear, my lord?
Yes.
Thereafter, may I take your lordships to page 69. Whichever page 69, my lord will kindly see. Last, governing body.
Yes.
Now, governing body, my lord, who were the members of the governing body, my lord? The affairs of the association shall be conducted, managed and administered by a governing body called the Apex Council, which shall be considered as follows. The president is elected, my lord. The vice president, the honorary secretary, all elected, joint secretary, honorary treasurer, all elected by way of election by the district association. There are 12 district associations in the state of Meghalaya. Now, my lord will kindly see. One member to be elected by the affiliated district association and the former international player members at the annual general meeting. One Mr. Shubha R. Mora has been appointed, my lord. So far, governing body member is concerned. Next, kindly see. 2 representative players, 1 male and 1 female to be nominated by Cricket Players Association from amongst those of its member hail from Meghalaya. No female appointment has still been made. My lord will kindly see. 1 person to be nominated by Accountant General. That has been done. Now, may I take your lordship to page 72? Yes. My lord, page 72, powers and duties of Apex Council has been laid down. Under heading A, B, C, D, and it comes to, my lord, W. Apex Council doesn't have the power to appoint ombudsman, my lord. Am I clear, my lord? There are other functions, my lord. I am not reading and wasting the valuable time of the court. Next, my lord, 18, my lord, at page 74, power of office bearer, my lord, function of office bearer. Now I take your lordship, my lord, to page 80. Yes. Annual general meeting and special general meeting, that is 25 and 26. Annual general meeting of the association shall be held everywhere not later than so and so. So this is that thing, my lord. I am not reading it, my lord. Special general meeting, my lord, will kindly see. A special general meeting may be called at any time by any of the following procedure: by order of the president, my lord. Roman 2, by a decision of the Apex Council. 3, by requisition signed by not less than 1/3 of the total number of bona fide members of the association. Am I clear? So if a requisition has been there from the district associations and at least 1/3 comes in, out of 12, even my lord 4 comes in, then special general meeting it can be held, my lord. Now, my lord, will kindly see 40, no? 86. Yes, 40 at page 86. Kindly see ombudsman. Here in this case, ombudsman has been outcome of the Apex Council decision. Language, there is no ambiguity. The association shall appoint an ombudsman at the general meeting, annual general meeting, my lord, for the purpose of providing an independent dispute resolution mechanism. The ombudsman shall be a retired judge of a high court so appointed by association after obtaining his/her consent and on terms as determined by the association, in keeping with the dignity and stature of the office. The term of office shall be 1 year subject to maximum of 3 years in office. The Apex Council shall frame regulation regarding the discipline and conduct of the players, so and so, so and so. So what I am on, in the latter matter, there is no avertment in the petition that how ombudsman has to be appointed. I'm sorry. We expect orders we submit with fairness to the honorable court, my lord, in a constitutional court. And we expect all fairness from the parties also. Not even a single avertment so far with regard to appointment, never been pointed out to the court. How does the Apex Council comes into for appointment of ombudsman? It is the annual general meeting. All the stakeholders, 12, my lord, in numbers, they have to take a resolution with regard to this. The Apex Council have no role, my lord. Duties and functions, no way they can appoint this, my lord.
Yes.
So, my lord, what I am on.
So, your prayer here is.
Yes, to suspend this, my lord, with regard to at page, my lord, will kindly come to at page 29.
Again, doesn't it overlap with the.
No, it will not overlap. Why? When I come to the next matter, my lord,
yes,
then it will be clear, my lord. Because we have suppressed nothing from the court. We have come with clean hands. But I don't expect them from this. This is a letter written by the president on the basis of Apex Council resolution, wherein Apex Council doesn't have the power and the jurisdiction with regard to appointment of ombudsman, my lord. So this is one and substance. I would pray with folded hands. This is blatant violation of the constitution of MCA on the face of the record. The Apex Council doesn't have any power with regard to this, and the person concerned, my lord, wherein the person honorary secretary doesn't sign it, the joint secretary doesn't sign it, and my lord, when the honorary secretary, my lord, at page, my lord, will kindly see, please go, yes, kindly see, my lord, after this appointment, my lord, will kindly see at page 31.
Yes.
They have suspended me. That's a different cause of action. I'll come to it later on, my lord. Page 31, my lord, will kindly see. Emergent Apex Council meeting of MCA of 9 May. NCA conference hall Polo Ground. Dear, with our reference, so I'd like to inform the emergency Apex meeting will be held on so and so at 3 p.m. to discuss proposal made during Apex Council. So they this letter has been circulated. Why? My lord, I'll come to that. What are the proposals that Apex Council doesn't have the power and jurisdiction to ratify and appoint an ombudsman? Yes, page,
yes, sir.
page 32, my lord will kindly see. 33, my lord will kindly come. Point number 12.
Yes.
This is with regard to the minutes.
Rule 40 you shown just now.
Yes. Yes. Rule 25B4 and Rule 40 MCA constitute specifically provide the ombudsman shall be appointed by annual general meeting. My lord will kindly come.
For the respondent. Yes, we understood, I think.
Yes. And my lord, in the next matter, my lord, this has been stayed. Kindly see, my lord. This document has been stayed by Honorable Court.
Which document?
In the second document, my lord. I am coming to that. That, my lord, will kindly come to that resolution, my lord, at page 40. Because special, my lord, special general meeting was called for. At page 40, my lord, will kindly see to the Honorary Secretary Meghalaya.
Yes.
Now, who has signed it, my lord? On 24/6/2026 by 8 associations out of 12. So 4 is requirement of law as per section 26, clause 26. 8 has given in. So I have convened the meeting with regard to, my lord, the special general meeting, my lord, place 43, and this has been stayed by this honorable court in the earlier matter. Because in the earlier matter, it was never pointed out to this honorable court that the Apex Council doesn't have the power.
We have to take matters together.
Yes.
It seems to be that overlap.
Yes.
Anyway,
let us come to the next matter, my
who's
lord.
appearing for will issue notice first.
Mr. Rao is up.
Yes, sir.
Mr. Rao.
Yes, Mr.
Your Lordship, has the paper book, my lords, in item number...
No, we'll just issue notice here first.
Yes.
So let's send counsel for the petitioner with so issue notice. You'll accept notice on behalf of one. Yes,
my friend will...
Yes, MS. You both I record both the names, senior counsels.
Yes.
Yes, so and so are present on behalf of this point number 1. Such no further notice assisted by MS Emberchang. No further notice on the respondent. This one number 2 represented by S. Lalu.
Advocate
S. Lalu.
Yes, I'm here. I'm here.
Yes, representative is present. Advocate General with MS S. Lalu. Such notice complete on all the respondents. On this matter, it is stated to be connected to WPC number
294 or 26?
294/2026, wherein the matters substantially in issue are also present here. So accordingly, the two matters to be heard together. Yes, here also next.
Yes, may I pray here for an interim relief? Why I am telling you, my lord, that nothing will remain in this. The matter will be infructuous. The appointment of ombudsman has been done in violation of the express provision in the clause itself, 40. So in that view of the matter, let it keep it abeyance till that day. Let the court decide it first. Because an illegal appointment...
One thing will not create any other, multiplicity of,
No, my lord, that will not create. It will stop.
Take it up first, and if we need to pass orders in that matter, then
yes. No issues, my lord. I'll satisfy, my lord. I'll satisfy to that extent.
Yes, and we have to hear them also.
Yes, of course, my lord.
I specifically spoke, Your Lordship, the powers of the Apex Council and the General Council on that day.
Yes. No, this was...
No, already I have shown it with regard to the satisfaction of this
case.
Yes, for slave vacating, my lord.
Yes.
Your Lordship will consider issue.
Yes.
Will issue notice on this? We'll hear you another day.
No, it is, my lord, here in this case, my lord, interim order has been passed.
Yes.
So that interim order has to be kept in abeyance till final disposal. Otherwise, my lord,
whatever it is, we have to give. We can't shut them down. We have to hear them also.
Otherwise, the matter becomes infructuous, my lord.
Not infructuous.
No, vacating will make it infructuous, my lord. Not the interim order will not make it.
Then, my lord, in that case, my lord, we will make an observation. Fixing a short date, giving an opportunity of them.
Let them reply. We have the matter. And the thing is that we can dispose of all the 2 or 3 reply, whatever.
Yes. So, will be subject to outcome of the writ petitions. All appointment would be subject to outcome of the writ petition. That will be suffice.
This means MC WPC 204/2026. This is an application for for vacating the interim order dated 1/7/2026 pass in the main writ petition. Stop. As the other party is already present as the you all been served. You all been served. You have been served.
Yes,
Correct.
at least
As the
one here.
The miscase one.
the miscase.
We have been served.
As the respondents have since been served, so this is matter for consideration of the instant. This is application for consideration on
short date, my lord, next week, my lord, if your lordship.
First in the ordinary course, because the other matter, your lordship had re-notified for the 21st of July.
Yes, Mr. Bhuya, you want when?
Silent it too. Yes, my lord.
In the main case fixed on 21st.
21st.
Our matter is fixed on 21st, my lord.
Then we'll have to go on 21st as 1 week.
Sunday, guys. There has been a Jubin Garg date, my lord. There has been a matter in like Guwahati, got very sensitive matter. So may I pray for accommodating on that day? 2 days thereafter, my lord.
Yes, you take the date.
Yes, I will. And my lord, that observation may be given, that the decision with regard to appointment would be subject of the outcome of the writ petitions, my lord. That would help me out.
The Honorable Court is deciding the matter on the
No, it's okay. That observation, my lord, I will pray with folded hands.
No observation. Both of the entire matters on the
Yes.
date.
So that observation may be given, my lord.
We'll list it on the 22nd.
22nd, my lord. That observation with folded hands, I pray. My lord, we are, my lord, before the court, honorable court, and my client is before, because the injustice has been done with regard to this. And prima facie, my lord, I would be able to satisfy this honorable court to that extent that ombudsman, it is the annual general meeting, no shortcut to regard
Today, but we have noted your submissions with regard to ombudsman, whether the appointment was as per the constitution and whether Apex Council has an authority at all to appoint.
Yes, my lord.
That's only.
Yes, my lord. On 22nd, my lord, the effort may be made to dispose of both the matters.
Yes, we've recorded that.
Connected matter, state is not party, my lord, so we do not have a copy. We will not be able to assist your lordship in connected item 5, my lord.
We'll serve a copy.
Anyway,
We'll serve a copy.
yes. This accordingly.
Item number 6.
Yes.
Obliged, my lord.
Yes, my lord. Please, my lordship.
Talking of quagmire of miscases, before you draft, you have to be very careful.
Yes, my lord.
These are basics.
Yes, my lord. I made a mistake, my lord.
Yes. Where's the MC number? 123.
Yes, my lord.
May I just, lordship.
Where's your miscase for recall?
My lord, my miscase for recall is now
203.
today's.
You want to recall the order passed in MC 123, correct?
Yes, my lord.
Lordship, may I just submit? Because as per the order dated 15/04/2026, only in that order she was allowed to bring a new application, but she have not enclosed, she have not even make a mention in this petition. That petition which is kindly see the order, Lordship.
Order dated?
Order dated 15/04/2026, whereby this Lordship has allowed to file a fresh application. It is, may I just read it, your Lordship?
See, please, Mr. Palma. That application first was defective.
Defective.
Withdrawn, file a fresh one, which is still defective.
Yes, my lord.
That is miscase 123. Then order was passed on 7/5/2026 that this is defect, please be allowed to withdraw and send this application. Allowed. But then in that, when she withdrew it, she didn't ask for liberty to file it fresh. So this one is just for recall to the extent that she may not file it fresh.
That's all.
So just leave it at that.
Yes.
Okay. Yes, this application is for recall of order dated. No modification of order dated
7/5, my lord.
7/26 passed by this court in this case 123/26 arising out of 3168 stop. MSOI Bank submits that inadvertently the prayer for liberty to file afresh was not made, though in sum and substance, the matter had been withdrawn to allow for correction of certain defects. So Mr. P. Sama has no objection and to the matter. The order dated 7/5/2026 is modified to the extent that liberty be granted to the
Application.
to the you're the
Applicant.
respondent.
This is respondent number
One, my lord.
One strong applicant to put in a fresh application.
I'm respondent 2 and 3, my lord.
2 and 3.
2 and 3.
Matters transclose allowed and dispose of yes.
Who's obliged?
Much less
In case due order passed in this case so and so, petition is permitted. How much time? 2 weeks time.
Yes, my
to
lord.
file in the necessary application.
Who's obliged?
Much less lordship.
Daily list item number 1.
But these are SOP matters, my lord. From 1 till.
Are they ready?
Ready, my lord. State has filed few affidavits, my lord.
We'll cover all the cases.
Because
Yes, my lord.
because only some departments they filed till now, my lord. Not all the departments.
So we have filed in the lead department, my lord. We have given the chart, if your lordship would recall, my lord, that textile department and all departments and rejoinder, they have got some time to file rejoinder. If they file, we
We will file a rejoinder, my lord.
You'll file rejoinder.
We'll
You'll
file
file rejoinder with affidavit.
We are still receiving some affidavits, my lord.
Yeah, with Dr. M. Mozika.
2 weeks time we'll file.
The place also to file rejoinder to the affidavits which have since been filed by the respondent in all these connected matters.
Right.
Prayers allowed with up to 2 weeks.
My lord, as far as paramedics are concerned, my lord,
No, but last order recorded also. What are the steps to absorb?
the nurses and paramedics, my lord. Nurses, some process has been started by state, my lord. But paramedics still now there's nothing, in spite of the cabinet.
Then application also to clarify on the steps taken to absorb and regularize some
Nurses
staff nurses,
and paramedics.
yes, and paramedics, as per the decision, as the policy decision of the state government.
Yes, ma'am.
He had a cabinet meeting, some of them to absorb. That also you have to look into. And yes, M.F. Haruna.
Yes.
Item 113, in item WC number 1, item 113 WC number? Number 326. The council correspondent number 6 is allowed 2 weeks time list together. After 2 weeks, all the matters is.
Till 115, my lord.
Till?
115.
115. 1 to 115, my lord.
Very good.
115.
Yes.
Item number 116.
May I please, your lordship?
1 second. Lawrence Manninga. Yes.
Your lordship, no, pursuant to the mediation, your lord, pursuant to the mediation, your lordship, geotagging was done and verification was completed, and full payment was released to us, your lordship. So this matter can be closed.
Yes, Mr. R. Pasanthi, the Constitution submits that pursuant to the mediation proceedings.
Yes, Lord.
Yes, the matter has since been settled out of court. Yes.
I'm appearing on behalf of Standing Counsel P.S. Nombri, Your Lordship, for respondents.
Yeah, this seems the submission also concurred by Mr. Rob. What's the name?
M.A. Lightman.
And Lightman, yes. According matter stands closed and disposed of. Yes.
117.
Papa. Yes, MSS Sham.
117.
Yes. 1, 5, and 8. After it's been filed, yeah.
No, Lordships.
No.
Lordships.
No after it's been filed as yet, nor anyone present on behalf of respondents 1, 2, 5, and 8. Just after 1 week, yes.
Obliged, Lordships.
118.
The problem with these government advocates. And then?
May it please your Lordship?
Yes.
Your Lordship will be filing the rejoinder in the course of the day.
Yes. Billing law.
Yes, your Lordship.
MS meeting to submit that rejoinder will file the fourth of the day. From this matter after 3 weeks for hearing.
Yes, Your Lordship. Highly obliged, Your Lordship.
119.
May it please your lordship. Lordship, we will be filing a rejoinder affidavit in the course of the day, lordship.
Yeah, MSS
B. Sarma.
B. Sharma submits that the rejoinder after we find the fourth of the day upon this matter for 3 weeks for
After
hearing.
3 weeks, lordship. Deeply obliged, lordship.
Item number 120.
What is this, Mr. Parsons here?
Respondents have filed objection.
For transfer?
Condemnation application, Your Lordship.
You filed
Your Lordship
objection?
will file in the course of the day.
You filed it? How many days delay?
12 days, Your Lordship.
We'll condone it.
Lordship, I have
You
mentioned.
12 days, so you objection.
Yes, Your Lordship. I have objections.
You receive copy.
If served, Your Lordship.
MSGC GC Marbo submit that objection to contempt file. This is the matter after 1 week for
Hearing, Your Lordship, on the delay.
sorry for further audit.
121.
Yes. What is this matter?
Yes, Lordships, this is a contempt, my lords. In this, your Lordships, on the last date, your Lordships, subsequent to your Lordships' orders, my learned, my lords, they were pleased to release the bank guarantee, my lords. This is the issue of contempt
Yes.
against an order of the arbitrator, my lords.
Yes.
My lords, my arbitration petition pertains to...
What's
my
it
lords-
for today?
My lords, today it is for the release of the retention bank guarantees, my lords. My
Yes,
lords,
Dr.
there are
Mozika,
total-
the contempt matter.
Well, we've taken the ground that contempt is not maintainable, my lord. And
Have you filed affidavit?
We file affidavit.
You file or not?
We file, my lord. And moreover, the order they are seeking to enforce, my lord, we have challenged that and civil division is pending before this honorable court, my lord.
My lords,
In the meantime, the question was with regard to 3 bank guarantees, my lord. One we have already released.
No, that we recorded somewhere.
Yes,
Where is it recorded? The miss case.
Lordships, in the last order, my lords, there was a miscellaneous application, my lords. In that, it is recorded that the bank guarantee is directed to be released, and subsequent to that order, on 3rd of July, they have released that performance bank guarantee.
Well, the matter will come after a week, my lord. In the meantime, we'll try to get some interim order from the court where civil division is pending, my lord. Because otherwise also the proper remedy is to file execution petition, my lord. This contempt, in my humble submission, is not maintainable. Because other high courts may be, because the original jurisdiction is with the high court, my lord. So order 39 rule 2A under CPC is maintained before the high court, my lord, in other high courts.
Lordships, on the last date, we had argued this issue, and I had shown that the remedy is under section 27(5) of the Arbitration Act, my lords. I had shown the judgment also for that. That this is the correct remedy, my lords, insofar as this is concerned. My lords, the only issue is this. My lords, now they have complied with half the order, my lords, by releasing 1 bank guarantee. Issue with respect to 2
The
other bank
only issue
guarantees.
is that they're saying they'll come to a week to await some orders in the connected civil division matter. That's the only thing.
My lords, let it be after
We'll have
the
it
week, my
after.
lordships.
Yes, we'll after 1 week. Yes, yes. As the DSGI praised that if 1 week's time be allowed to await further orders in the connected civil division application. Yes, after 1 week. Yes.
122.
Then we'll argue whether contempt maintainable or not. Yes.
Yes, ma'am.
Yes. None of them file affidavit.
No, Your Lordship.
Apologize, my lord. I'll have to seek some more time, my lord.
1 and 2, 3 and 4.
Lordship,
4, 3 and 4 is para respondents. Yes.
Please, Your Lordship, this is the 6th occasion that the matter is listed.
6th occasion?
Yes, Your Lordship.
Then let them pay costs 1 and 2.
My lord,
How much
kindly,
cost
my
you'll
lord,
pay?
we can't afford, my lord.
You can't
kindly-
afford?
No, lordship.
Yes, sir. The NG shall learned senior cannot get submitted due to unavoidable reasons. The applicant will be filed today. Stop. He praised once allowed 10 days time to file the said affidavit. So it's expected next day the affidavit should be on board. And you file it today. MS Emmer Chang for 4 submits that the affidavit since been filed today itself. Yes.
Copies may be supplied to me as well, Your Lordship.
Copies are given to you?
No, Your Lordship.
You give copies. Oh, will be filed in the course of the day itself. Yes.
Much obliged, my lord.
Much obliged, Your Lordship.
123.
Chief, I have taken fresh step to the private respondent again, Lordship. So here,
missent.
Yes, Lordship. Return back again. I have resent, Lordship, the same address, Lordship.
When is rescinded? On 15?
Lordship.
Yeah. No, no.
Lordship. Resend again, Lordship, through a post.
Sultana Sarkar?
Sultana, yes, Lordship.
Sulata.
She is the
come,
first.
It's come again. See, the first one. This is the first one you sent?
Then, Lordship.
It was returned to sender?
Yes, Lordship.
Now
because-
this Arun's missent. What does missent mean?
Missent.
Missent means what? The first time I come across this noting. What does it mean? First he sent to Tripura. Same address.
Same address, Lordship. Because I didn't get the father's name of the addressee, Lordship. So in the earlier postal remark says that because of the father's name was not mentioned, that is
Not
why
that, because there's so many people having the same name.
Yes, same name. That is why.
In that area, yes.
Yes.
So how was the court to address this issue then?
That is why I had prayed, Lordship, in the at the time of moving motion, Lordship, and court has some, although it was not recorded order, given the instruction to the Union of India to verify, Lordship, as to whether the lady is still survive or not. And if she survived, the law provide 50%, Lordship, and if it is not survived, then by virtue of being
BSF can't do this exercise. Right?
Why? Suppose you have to track fugitives who crossing the border.
The fugitive is okay, my lord, on border, but I don't think.
Then you
this-
can treat them as a fugitive and track them down. What is the court to do then? I've never heard of the missent.
That is why, that is my prayer. Let the Union of India can make an attempt to identify as to whether she is alive or not.
So the fresh steps have been taken upon the respondent number 5. The envelope has been returned with the noting within inverted commas MISSENT missent. Though this court cannot comprehend as to the meaning of the noting, some interest of justice, the learned DSC counsel requested to instruct the official respondents, that is the what's this one? Command in Bengal or is in West Bengal?
He has been retired from West Bengal, Lordship.
Very difficult then.
Yes,
How,
Lordship.
see, the West Bengal commandant, IG is in Shillong, and the addressee is in
This is Ashok
Tripura.
Khatun today, no? 47. This is 47, 48.
47.
Is requested to use good offices through the resident commandant to uh, find out the whereabouts of the respondent number 5.
Well, the police can be directed. Well, the police is in a better position to locate.
Instruct good office to instruct the commandant of which place this?
This is Lordship District Safahijala, Tripura.
The commander of the concerned district to seek information from the. It be which police station is this one, sir?
This Safahijala resident.
Will be lost in.
The red petition is so skeletal, no documents, nothing.
My lord, Vishalghar RD block.
No, which police station will be under? Tripura, which district?
My district is Safahijala.
Never heard of Safahijala district also.
Never heard of it also. They say in the Safahijala under so and so in Missen. They said it's under some other district or something.
But that is the address which I got from the.
You just brush up on the geography and then you come back. Yes, then the fresh steps taken by the has come to turn Missen. Who can comprehend Mr. S.A. Sheikh Council is allowed 2 weeks time to obtain at least approximate
Address.
Details.
Lordship.
Number 5. Have you filed affidavit?
They have filed, Lordship. I made a prayer for reason once that the service report is complete, then I'll.
After 2 weeks for the order. But we can't. How will you issue orders also? With those police stations that mention nothing is mentioned.
My lord, once that service report is completed, either this way or that way, then there is a rule for 50%, Lordship. Yes, yes, Lordship. Then, Lordship.
124.
Safahijala.
Yes, Lordship. I just received their affidavit. Let me just allow to go through and then.
Mr. Krishna submits that affidavit has been received. He press over his time to examine whether he has.
Within.
Yes, that after.
125.
What's first, Lordship?
Please, Lordship. So, although affidavits have not been filed, I would like to place a certain document, my lord, that's relevant in the matter.
What is this?
It says that it's not as per. Lordship would see, my lord, my long and short of my petition is that there is an OM by the central government to appoint the CVO. Now, this appears to be a letter by the person whose appointment has been challenged. 7 July, if I may read it, my lord, that although the EC has approved the undersigned's appointment as part-time Central Vigilance Officer for 3 years as per EC held on so-and-so, the CVC wide OM number so-and-so dated 11/6/2026 has not accepted continuation of the interim arrangement as received on 18 June 2026 and has advised NEHU to follow the prescribed procedure for regular appointment of a part-time CVO. Accordingly, advice is sought for processing further pending orders authorization from the CVC.
Now, where's Mr. Sen?
Lordships, I have.
Where's Mr. Sen?
It's their own letter.
Copy of the letter.
This is their own letter.
Lordships, I have submissions. Lordship, I have some instructions from the client. Lordship,
From the client?
From the respondent, Lordship.
Person who has issued this letter.
So far as engagement as the part-time CVO, Lordship, that is only for 3 months, Lordship. Now,
3 years, 3 years.
3 months, Lordship.
It's for 3 years.
Part-time, Lordship.
This is her own letter.
She's appointed as a part-time, Lordship, not full-time. So the period for part-time is 3 months, Lordship.
Nothing like that. This is her own letter, my lord. This is the very respondent who's writing her own letter.
You have written yourself.
Yes.
That they should.
It's for 3 years and it has not been accepted.
Yes. You have a copy of the letter?
I don't have a copy of this, Lordship.
Yes, today, Mr.
I don't know because the same person has been appointed as a registrar.
This Beasley.
Yesterday.
In my petition, I am only concerned with this that the the CVO should.
We understand the CVO should be appointed as per due procedure.
That's all, my lord.
And that this person is not qualified, eligible to.
And it appears from this her own letter.
She also has said that
it has not been accepted by the CVO.
Appointed as per due procedure.
Yes. So central government has not
accepted. 7th July.
7th July, my lord.
Yeah. Today, Mr. S. Deb has produced a letter dated 7 July 2026. Written by the respondent number
my lord, 3.
Respondent number 3 to the registrar. Respondent number 6. Now, so with regard to the appointment of the CBO and the objections that have been received from the Central Vigilance Commissioner. Yes. So as the respondents do not have the same, for the petitioner to supply copies just for further orders after 1 week is
1 week. Obliged.
126.
Is for affidavit.
Where's the respondent?
Mr. BK Singh is appearing.
Any urgency?
Not sure because
any interim prayer?
only no cause of action because I've been blacklisted, Lordship, and my contract has been terminated.
What do you mean blacklisted?
Blacklisted, Lordship. So I just
No, it's already there, the order.
no cause of action, Lordship. So far as
None appears for the respondents, though on 19/6/2026, 3 weeks time had been sought to file affidavits in the interest of justice. Let the matter appear after 2 weeks. After the file, the meanwhile, some interim orders need to be continued till next day.
127.
Same order.
128.
Your Lordship, I have received
File
the
affidavit.
Yes, my lord.
What does it say?
Hospital contention. They said that I did not go for regular follow-up and for regular checkup also, Lordship. So, Lordship, I would like to reply, Lordship. I would like to file my rejoinder affidavit, Lordship.
What are you seeking here? Compensation?
Yes, my lord.
From government hospital?
On medical negligence, my lord.
Yes, Lordship.
You do not take care of yourself.
It's not like that, Lordship.
And it is said it cannot be attributed to any negligent surgical procedure. You do not follow up. Anyway, yes, MS after since been filed by the respondents, Ms. Kasyamlang, please respond about 2 weeks time to seek instruction to file a joint so advice.
129.
Lordship.
Respondent to file affidavit, Your Lordship.
Yes.
My lord, we are still awaiting instruction.
What's the matter about?
They are challenging the DPC, my lord. This is the second round of litigation, my lord.
Yes, I spread further 2 weeks time allowed to 1 and 5 represented by M. Colony and 6.
Yes, Your Lordship. Similar prayers.
So affidavit is
130.
For affidavit, bring with some time. So fresh matter.
This is an interim order.
Yes, as paid for the 3 weeks time allowed for affidavit and some orders if any to continue the next day. Yes.
131.
I'm not hearing it. Huh?
May please, Your Lordship. Lordship, I am entering appearance on behalf of the bank, my Lord.
For number 2.
Lordship.
Yes, M.E.N.G. Shilla, the appearance in behalf for number 2. Such notice complete on all the respondents. It's freezing matter.
Yes, my Lord.
So will he come with instructions? She prays for about 1 week's time to obtain instructions.
2 weeks time, my Lord. I'll also need a week's time, my Lord, to file my status report, my Lord. And to respond.
Okay, she prays for about 2 weeks time to obtain instructions. Similar prayer by MOCI Bank for respondent number 1. Yes.
Much obliged, my Lord.
132.
Now what interim prayer you have here?
Lordship, my interim prayer, this new development, Lordship, I've been
discharged,
reported back to my parent duty, Lordship.
Then?
Parent
It's gone back to his, so no interim order is called for month.
No, Lordship, this is only an interim prayer, Lordship, because we'll have to file an affidavit, Lordship, because the representation has been rejected.
He wants to be absorbed in engineering branch, my lord.
What is this?
This is the
movement order.
Movement order, Lordship. He has already joined the.
He's gone back to his parent department, my lord. But his claim is that he should be permanently
Okay, you
absorbed
file affidavit then.
In the main case, we'll file affidavit.
We will not record anything.
No,
Take it back. Yes, sir. Dr. M. Musica, please response allowed. We for a technical affidavit. Just thereafter also.
No, only the last order is interim order. Interim order is not called for.
Yes, it is also submitted by the parties that interim order.
Lordship had observed that interim order will be considered today. But in the meantime, they have passed this order.
Those stop. Those observed in the last order that in the prayer for interim orders will be considered today, Mr. M. Nongpur, that submits that due to developments whereby the Persian Sims rejoined his parent unit, the prayer has become fructuous. Right. Yes.
At this stage, only pray for expeditious hearing.
Yes, sir. For me also.
133.
But this is the foreign tribunal matter.
What records?
Well, we were able to retrieve the electoral roll of 2012. Now, what I have done is, after we received the copy, I shared it to my learned friend to obtain instructions whether that will suffice. I have never heard it back from him. It's been 2 weeks.
I inform also, sir, that it seems the petitioner's name and father's names are there.
So, will it serve as purpose before the foreign tribunal?
No, my lord. In the foreign tribunal, my lord, specifically prior to 1971, my lord, it says which is why he was been declared foreigner to establish his citizenship. The documents, the electoral roll.
They have to
yes, my
refer
lord.
to pre-71
prior to 1971, my lord.
That's why it's 69.
Yes, my lord. My lord is correct, my lord.
That won't suffice.
12 will not suffice because the appeal is yet to file with regard to the pertaining to this document. The moment
in detention center now.
He is in detention center, my lord, under Gwalpara district, my lord.
So any idea when he be sent to Bangladesh?
As of now, I'm not in.
Just send back, correct?
They used to, my lord. They used to send back to the Bangladesh. My lord has heard about the all news and all, my lord. All of it at midnight they used to send without any having communication to the other state, my lord, with Bangladesh. Neither signed any MOU between the state. That is separate issue, my lord. They simply in the border they send it to the Bangladesh, my lord. So many incidents happened, my lord.
So if they accept it, they not accept it.
They will not accept, my lord. And most of the cases, my lord, people are died, my lord. People are died, my lord. And recently, Honorable Supreme Court in 27 foreigners case,
12 orders of
27 persons has approached Honorable Supreme Court and Honorable Supreme Court.
Yesterday, day before.
Order is not yet uploaded, but in the story has uploaded in the life law. that without fair procedure cannot declare
What
foreign.
fair procedure? What will be documents will be accepted?
Only documents, yes, ma'am. Fair procedure and the documents. Judgment is not uploaded. I have not gone through the judgment.
So what are we to do in your matter?
My lord, my only prayer is
Take down Mr.
the electoral roll, and in the other case,
records could be traced. That is electoral roll of 2012 has been furnished to the writ petitioner. The writ petitioner's counsel stop. Mr. Sassan appearing for the petition submits that this document will suffice. What should we do then?
For further instructions, we will try. We can only try, my lord.
Yes, my lord.
Yes, Comno? Will not suffice. Is not suffice. Will not suffice as documents prior to 1971 are required. Next, under submission, Mr. The counsel for the respondents is about some 3 weeks further time to attempt to obtain any records on it. Just after 3 years.
My lord, after 2 weeks, he is in detention, my lord.
Can't help it. If no documents, then detention will be.
Yes,
They're
my
not
lord.
being sent out now.
My lord, only one suggestion: if election commission, our state chief electoral officer can certify the family of the person after
How will
verify the
He's not
documents.
having authority can be accepted by the foreign tribunal. It won't be accepted.
My lord, well, the citizen
I even
of
say
Meghalaya.
passport also travel document.
My lord, that dispute is, my lord.
As per Passport Act, that is issued Indian citizen.
My lord, in passport case, my lord, where go for any other country, then we are treated as Indian nationals.
No. Now they're saying even purpose SIR also passport not be accepted as a valid document, right?
Yes, my lord.
Yes. Anyway, those other issues.
My lord, yes, my lord. Obliged, my lord.
On behalf of respondent number 3, stay.
You have the documents.
No, Your Lordship, today I am proxy here on behalf of
Then
Mr.
you don't record
Gargu.
anything.
134.
Government applications all going on proxy only.
134.
May it please, Your Lordship. I am praying for some time, Your Lordship, to file our affidavit, Your Lordship.
That's on 25 is a yes.
Yes.
What's the matter about?
This is outstanding dues for the construction of dams. Yeah.
Personal dues?
Outstanding dues for the
Outstanding dues, Your Lordship, for contract.
Construction?
Yes, construction.
Yes, MS Anima prays for further 2 weeks time. Appropriate instructions to file affidavit.
Much obliged.
135.
It's connected, Your Lordship.
Same order.
136.
Lordship, they were supposed to file a affidavit on.
It's just the second time it's come. Yes.
The affidavit will not be required. Well, I have the instruction.
What's the matter about Mr. Chitri?
But this is.
Lordship, this is a matter regarding ex gratia compensation.
We have
Yes.
paid within 2 weeks time. Right?
Yes.
Para 2. It is under process and will be remitted to the petitioner's account within 2 weeks time. By now, must have been done also.
We take instructions. We visit on Tuesday, on Monday. Yes, Dr. N. Mozika and the DSGI also submitted that the payment of aggravation with petitioner has been processed since 29 June 26. So to this effect, the Nursing Council has produced a communication dated 10/2026 and communications dated 10/26 and order dated 29 June 26. Copies of CM will be made over to the council of petitioner just next week for instructions. Yes.
Obliged, Lordship.
137.
Yes.
In this matter, I'm for the GAGDC, my lord.
Where's
I
as
need
per
about 2
Shaji
weeks
1 and 2? State, where's the state? So it's formal party, Mr. Pasanthia.
Yes, Lord.
Well, I'm for respondent number 3 to 7, my lord.
3 to 6 is GHADC, Your Lordship.
3 to 6, my lord. I'm praying for some more time, my lord. This is second time it is coming up, my lord. So I need some more time, my lord, to obtain the Parawais comment.
What about 7?
3 to 6, I am there, my lord.
7 also.
7, Your Lordship.
It's also GHDC.
No, that's what my lord. I'm for respondent number 3 to 7, but Mr. Paske is telling that I'm for only 3 to 6.
3 to 7, yes. None appears for the state respondents. Mr. SD for respondents 3 to 7. Please follow out for the 2 weeks time to obtain instructions. What about number 8? You didn't take steps number 8.
Your Lordship will seek some time to take steps, Your Lordship.
Why?
Inadvertently, Your Lordship, steps were not been taken, Your Lordship.
So it is noted that though notice was issued number 8, Mr. Paske submitted due to inadvertent steps have been taken. He prays for how to take steps in the meanwhile. Yes, this after 2 weeks.
138.
Deeply obliged.
Yes. Ready?
Please, Your Lordship. I'm for respondent number 6, Your Lordship.
Entering appearance today?
I have just entered into the appearance.
1 second. 1, 2 and 3 is...
Yes, I'm appearing on behalf of Miss PS.
4 and 5, Lordship. We have taken
steps.
Yes, we've already taken steps.
They've appeared.
Only 6 is appeared.
6 you are Sadar not right.
Yes.
5, 4 and 5, where's MS Njishala? 4.
Then the other matter, this is a fresh matter.
For the fresh matter?
Yes. They appeared earlier, which was withdrawn. And this is a fresh matter. So we've taken steps. Actually, they have not appeared.
Mr.
Imar Banyang.
Imar Banyang. Mr. Imar Banyang has...
We are allowed to take dusty service for respondent 5, Lordship.
Respondent number
4 and 5.
6. Though AD card note service complete on 4 and 5. No appearance. There's no appearance on the behalf today. What do you want?
Dusty service 4 and 5.
Your Lordship will file a counter affidavit on the next day.
After
Yes.
3 days?
Oh, no, Your Lordship.
When?
2
How
weeks.
long? 2 weeks. Any urgency, Mr. Marpan?
There is a miscase for an interim. Urgency is not there, but the order is of 25, so it's fine.
Yes, sir.
Be taken up in the next date for interim.
Mr. Lajman, Vice MSP, if nobody 1 to 3. Response allowed 2 weeks time for affidavit. Similar time allowed to respond number 6.
Then dusty service for 4 and 5.
They already been served.
Already, sir. Then I'll file an affidavit.
Yes, they already been recorded here.
Okay.
Yes, after 2 weeks for affidavits and for appearance of 4 and 5.
4. Pleasure.
Hearing item number 139.
I'm yet to receive the instruction, my lord. I was directed to take instruction, my lord.
My lord, that there exists a separate account because last occasion, my lord, Lordship has already heard this matter.
They are examining the record, my lord, because certain maps which was placed, my lord, before this honorable court, my lord, that we have to verify, my lord.
Unification of Chibongri.
Yes.
Aking 324.
Yes, my lord.
You see, it still exists.
Yeah, it exists, my lord. I was able to show, my lord, from the GPS mapping also, my lord, that there exists a separate Akang. And from the Moza number also,
Not part of Damalgiri.
No, no, it's not part of Damalgiri, my lord.
See, you've been asked to get instructions in 13.3.
Yes, my lord.
My lord, I need some more time, my lord. This is where, my lord, one statement can either build up a hacking or it will not build up a hacking, my lord. That is
Create an
what I
hacking
want to be very
or
certain
destroy
before
one.
I submit, my lord.
Yes, Mr. SD submits those praise for further time to obtain instructions. It is noted that this court, by order date 13/3/2026, had sought for the same as it relates to the identification of Chibrongre, CHIBUNGGRE, hacking 3 Roman 3 capital dash 24 if it's still in existence. As the matter is of some importance, for the times as it's allowed.
I'm paying for 3 weeks, my lord.
Just after 3 weeks, yes.
Well, highly obliged, my lord.
Highly obliged, my lord.
142.
Here also, my lord,
In
is
this
supposed
matter also, my
to,
lord, I'm praying for 3 weeks time, my lord, because I need to complete the instruction, my lord.
the records were supposed to be placed.
Record with praise.
Yes.
No, my lord, I'm yet to receive, my
They were
lord.
supposed to place the records, my lord.
Yes.
I'm yet to receive, my lord.
16.3.
I'm praying, my lord.
Record of instant case. See the date on which Changre Sangma was entered GT record together with husband Singh Changmarang. Yes, and just Mr. SD raised for them to produce the record. Stop. For this matter of 2 weeks. Yes.
This also I pray for 3 weeks, my lord, because specifically they have to give us the instruction, my lord. They have to verify also, my lord.
This is much simpler. It's only whether in which date was it entered GT records.
Yes, my lord.
The name of Mr. P. Sama's
Yes,
client.
clients. Yes.
Yes, yes.
Yes. So I'll pray further to
I'll try, my lord, in 2 weeks.
Highly obliged, my lord.
143.
Lordship, kindly allow me to withdraw this repetition, Lordship, with liberty to file fresh.
What's the issue about?
Cancellation of my appointment, Lordship.
This is the case, Lordship, my Lordship, my...
Of son-in-law?
Yes,
Yes, sir.
Lordship.
Hard luck, yes. Mr. Lasungria prays for how to withdraw this application. For you under submission. Understands personal withdrawal.
With liberty to file fresh, Lordship.
Will it be filed fresh?
Lordship.
Mr. Lasungria prays they without to withdraw this application, however, with liberty to file a fresh, if so advised. Matter of stands closed. On withdrawal, however, liberty has prayed.
Master.
Obliged, Lordship.
144.
There is a new development, my lord. There is an agreement between the state government and the Garois Autonomous District Council that they will clear all the gratuity. So there is an agreement, my lord. That agreement has to be brought to the record, my lord.
The last order you've seen, 6/7/26.
I've seen. I've seen, my lord. I've seen. Here, my lord, the case is this now. Initially, it was decided that it will be paid by the district council because they are the staff of the district council, my lord. But now, my lord, after that, all those things has happened, my lord. State government has undertaken that they will clear the dues, my lord. And there is an agreement also. Last time I have placed.
Is it down party here?
No, state is not make a party.
Why you not been a party?
Because he was not working under state. Now this is after filing the repetition, only they are making statement that there is an agreement.
For the benefit of your own case only. You don't mean party. That's anyway.
Lordship, what happened next?
Anyway, making objections, say objections, sometimes will lead to an anyway. Yes. SD, what's your instructions?
My instruction is this, my lord. There is an agreement signed between the district council and the state
That
government.
an agreement is
that they will clear,
executed between the state government and the district council with regard to satisfying the dues. Oh, the dues of the petitioner and other similarly situated persons.
Yes, madam. Gratuity.
He prays
Gratuity
that
of
gratuity, yes. The due, the gratuity. Also, dues or gratuity. He prays for, he's allowed 2 weeks then to bring the agreement on record.
on record, my lord.
145.
Yes.
Please, your lordships. Lordships, is the transgender matter, the matters, the connecting matters in the Supreme Court are still pending. My
So one thing I must declare, the thing is that there's in the IEM there's no provision for reservation for
My lords,
these categories.
My lords, the Supreme Court is seized of a matter where the centre is supposed to show compliance to the NALSA judgment in education as well as employment areas, my lords, for reservation for transgenders.
Now it's on vacation, so Supreme Court, correct?
Lordships.
Yes, MSK De Cruz, General Counsel of Petitioner, submits that the matter is still pending consideration for the Supreme Court. She prays the matter is up to 6 weeks to await the outcome.
Fully obliged, lordships.
Prayers allowed is up to 6 weeks. Yes.
Grateful, lordships.
147.
Sapano. Maham Rising. What's the matter about?
This is regarding the regularization of non-teaching staff, whereby the Garo Hills Autonomous Council actually initially was appointed by the
Administrator.
Yes, administrator. Thereafter, by the virtue of the Meghalaya taking over of District Council Lower Primary School Act 1993.
Where's the judgment? What are the judgments?
It is the other judgment I have enclosed is also in the page 45 till 57. Are there many judgment where this is the cover case, my lord, actually.
No, my lord. 1994 is the act, my lord. And they have to complete 5 years. He is appointed after that.
After 94?
My lord, yes. They have been
After 94?
June, my lord, June. After June. After the act came into being, my lord, which clearly stated that they have to complete 5 years, my lord. June 2000.
Prior to 94?
Yes, my lord. So they have not. They have been appointed subsequently.
No, kindly see only the page 35.
Appointment order.
Now whether administrator has any power to appoint even after 94?
No, my lord.
After that also they have been appointing. Recently there is an order given by Lordship. May I just place it? Give me this one.
My lord, may I have page 21. He has enclosed his appointment order, my lord. He was appointed thereafter, my lord.
Kindly see this order, my lord. How about this one?
April 1996, my lord. The petitioner was appointed.
Recently, this is the cover. It is covering my case also, my lord. The para 9 of this. Recently, they said they will consider even non-teaching staff, and even in the para 38 of my case. Where may I just read it? Yes, 9. May I just read the lordship? That the committee.
No, but yours is you should be appointed when you should be at the district council, not after the act. You've seen this?
He has not given me a copy, madam.
Give a copy.
This, yes.
This is from your law department only. How come you got a copy of this one?
No, it was submitted by the one in one case. We have got it from the. They
How
have
do you
brought
get this copy?
We are asked from the advocate who is appearing in one case. Say in the case of Sengman Sama Contempt case number 30, 43 of 2055, where I have asked for the copy.
No, it appears this for the teachers,
Para
madam,
nine.
not for non-teaching staff.
Teachers. The last line is even it includes the non-teaching staff, and even para the page 35.
No, you're not non-teaching staff, but whether your case stands if you're appointed before 94. 94, the act came into being, whereby the state government had taken over the lower primary education in the entire state, run by the district council. Correct?
Yes.
Now, for those employees teaching and non-teaching now, there will be the responsibility of the state, to give them retirement benefits or other service benefits.
Yes.
Correct?
Yes.
And at par with state government employees. But your case is that you appointed temporarily
1996. 1996.
2 years.
But one thing you kindly see, Ms. Colney, although he might not come under this, right? Yes, but then it's upon 96 by the Deputy Inspector of Schools, Ampati subdivision that time. So his appointment will not be at all. We cannot at all relate to your district council thing. It's a totally different consideration altogether.
Lordship, may I just kindly see.
So your prayers only be for graduation. Were you appointed against sanctioned posts?
No. No, madam.
No, we were getting the salary of sanctioned post. Even now also I'm still working.
You're still working?
Yes, still working.
Another thing, because this district council thing, how do you say the appointed? This was district council school prior. The school you appointed office in the office.
Yes, my lord.
It's not a school. What are you talking about then?
Non-teaching, my lord. He was appointed as a peon in the office, my lord.
Yes, so
on a temporary basis.
Not a question of this act.
Yes,
being
my lord.
applicable at all.
So he is taking reliance on that act, my lord, that
No,
he should be
it's a
regularized.
simple case of regularization.
Yes. Yes, Lordship. Kindly have a look page 35 where I was just, page 35 where they have considered my, they have stated that they will consider my regularization. Page 35 till the then also yes is page 35 to 38. The last page 35 annexure 8, my lord. The point number F. Just I will read it. Will not read whole thing.
No, listen. With reference to update to you, can you cross check? They did appointment of the staff of GHEDC. Doesn't cover you at all.
No, Your Lordship. Just they have.
So you went on a wrong. What do you call it? On a wrong premise that I am under this council school. Where's the show appointments at this council school? Where is it?
Kindly see the page,
come to appointment order.
Page 39, my lord. Where is my name also? They have provided. Before that, page 30, they have stated that in this connection, government is requested to kindly regularize their service and consider to taking over the service of the non-teaching staff by the state government for their pension benefit. So, along with this memorandum, this cabinet memorandum, they have
name appears here.
Make a statement.
These are the list of the staffs, my lord, not actually those who will be considered. My friend is interpreting wrongly.
Not
the subject of the letter clearly says those who have completed 5 years. So he has not completed in 1994. No. He was appointed in 1996. So these are general lists,
page 39 where my name also is they have enclosed page 40. They have, my name is there. I'm from Risubel Para. They have provided my name. Person K Sangma. Then similar situated person, my lord, on the.
But the appointment is not by district council. How does the chart wrong? See appointment order. Appointment order page 20. 1. See where it says. Where does it say it's district council appointment? Where? Where does it say? Who prepared this chart also don't do own.
No, my lord, these are basically for the purpose of district council, my lord.
Who appointed? Who appointed by whom?
Yes,
everything stems from the appointment order.
Deputy Inspector of School.
Where can you show that it's linked to a district council school? In the office, where? And who prepared this chart?
This is
where the chart came from. You made it yourself.
No, not myself. This Commissioner Secretary to.
Then where's signature? Who prepared the chart under whose signature?
Commissioner and Secretary to the Government Meghalaya.
Where? Mr. Sangma, this is unrelated, this is unrelated. Details 47 of them are here. Very strange. In the course of hearing, it's noted that the link which is sought to be established by the petitioner, that is appointed at the council school, does not appear to be correct from the records. Though a chart has been appended,
Lordship,
though a chart has been appended, which is purportedly on a cabinet memorandum. Stop. A perusal of the appointment order dated of the petition dated 15 April 96 would show that his appointment is his temporary appointment is an office peon in the office of the Deputy Inspector of Schools, Ampati Subdivision at that point of time.
Kindly see, my lord, the page 43
on the said cabinet memorandum.
The Hamtom case,
yes.
Lordship,
yes.
Same charge from the same charge.
Yes.
Page 43. Just wanted to same.
Let's get clear that thing here first.
Lordship,
there's no link between your
because from the same link, people, Lordship, the earlier order has been passed. Then this Hamtom case, another they already got.
We'll see the
147 to 150 is connected. There are 4 writ petitioners, madam. 147 to 150.
Yes.
151.
Can't understand that. How?
What's the source?
Please, Your Lordship. Your Lordship, this matter pertains to non-payment of my salary, Lordship, in the Bagmara Municipal Board since the year 2021.
Till date?
Till date, Your Lordship.
What is
Facts, my lord. These are incorrect facts which have been placed by the petitioner, my lord. My lord may kindly come to the two affidavits in file, my lord. One by the Tura Municipal Board and one by the Bagmara Municipal Board. If my lord may kindly come to the page 4 of my affidavit, that the Municipal Board of Bagmara, which they have filed, my lord.
Yes.
My lord may kindly come to serial number 4, my lord. Paragraph 4, my lord.
Yes.
That the answering respondent, that is the Bagmara Municipal Board, has not withheld the salary of the petitioner as claimed by the petitioner by her since March 2021 till date. Whereas, in fact, the petitioner has been paid her salary by the Bagmara Municipal Board since April 2021 till date. Next paragraph, my lord. In such regards, the petitioner has been duly paid her salary as per community organized NULM at the rate of 15,000 per month since April 2021 till date January 2026 under the capacity of building and training component of DA NULM. Moreover, the petitioner has never objected to the same, which pertinently is done directly to her bank account bearing account number so and so, State Bank of India, Tura branch, Tura Bazar branch. Moreover, the said aspect has been utterly suppressed by her before this honorable court for the reason best known to her. This, my lord, till January, my lord, when we have filed this affidavit, my lord, 15,000 has been sent to her account directly, my lord. How they can say that they are not receiving the salary? Let them verify.
If I may,
and
Lordship.
This fact has been suppressed by them, my lord, before this honorable court.
If I may, Your Lordship.
Yes.
This is a central scheme, Your Lordship, where I've been receiving my stipends for 15,000.
No. What is your prayer? Let's see.
To release my regular salary, Your Lordship.
You are appointed as what?
As a community organizer. I was appointed in the year 1998 and I was retrospectively regularized in the year 2000, Your Lordship. And this central scheme was only introduced in the year 2013. I was a regular employee before I was engaged as a scheme-based worker, Your Lordship.
And also, one order says 29 August 2015. Regularized on 2015 on a regular pay scale.
Yes,
the service regularized respectively from 2000. So from 15 to 21 you paid regular salary?
Yes, Lordship.
What was the scale?
It was at the tune of 39,000, Lordship.
You were receiving?
I was receiving, Lordship.
Then after 21 you paid me 15,000?
Yes, Lordship.
Have you said that in written petition?
No, Your Lordship.
Why?
That was not. Because that was only the salary I've been receiving as a.
No. Whatever it is,
yes, Lordship.
Whatever amount you should have disclosed that to differentiate between what you're getting from the scheme
yes,
or what the due salary. Have you made any averment here? Maybe withdrawn
in my rejoinder, Lordship. However, Lordship, my prayer for my regular salary still stands, Your Lordship.
It doesn't stand because you suppress materials. You should dismiss it actually, but then you won't dismiss it outright.
If I can take Your Lordship to page 13.
21 till date. See that non-payment salary despite regular charge duty, amount of forced labor, equal protection, the law, right to livelihood. Extreme branch hardship. But you're getting that money, 15,000 whatever, may not be your regular salary. But the thing is that you should have disclosed that in the petition.
There may be a dispute.
Otherwise we'll this is, you can't file a petition suppress materials like this. You should have come in your petition that you appointed regularly from 15, respective regularized from 2000. You're drawing regular salary in this scale up to so and so. Suddenly you've been placed in a scheme where you're now be deprived. The thing is that it goes a different road altogether. Your case, it's not a case of denied salary. It's a case of denial of your service benefits and you're being placed in the. You can't be pay scale or pay will donate the rank also. Correct? If you deprive of your regular pay, there's a different case. Deprived salary is a different case. Then you join 21 as a community organizer. You take instructions, yes. For sure. After him, some like Mr. Lasang, we have paid with instructions. You start carefully. But a joint will not suffice. For sure. Yes. And where were you? The other matters of call when your names are there. We're going to record. We're going to record it in the order sheets now.
I keep running, but then
This is don't make excuses. It's not only one government case. It's 3 matters today. Yours matter, another matter. Council is just here. Next matter is called out. Council disappears. If that is the kind of respect or regard you have for the court, we know what to do also. Yes.
Apologies, my lord.
Hello,